Good morning, all. I request all the participants to please be seated. I request all the participants to please be seated. Our guests are about to arrive. Distinguished guests, esteemed faculty members, policymakers, participants, students, ladies and gentlemen. A very good morning to all of you. It is an honor and privilege to welcome you all to this international conference on synergies of law and economics, pathways to Viksit Bharat 2047. Today, we gather in this hall to bring together the finest minds in law, economics, public policy, and governance, united by a purpose, which is to explore how the synthesis of these disciplines can create transformative pathways for a developed India by 2047. To begin with, a timeless ritual embodying triumph of knowledge over ignorance, I would request the guests to kindly light the lamp of wisdom, seeking blessings from the Almighty. Thank you all. I would now request Professor Dr. S. Suryaprakash, Vice Chancellor, National Law University, to felicitate our chief guest of the day, Professor Dr. Devinder Singh, Vice Chancellor, Dr. B.R. Ambedkar, National Law University, Sonipat, Haryana. Next, I would request VC Sir to felicitate Professor Dr. Ram Singh, Director, Delhi School of Economics, University of Delhi. Thank you, sir. Next, I would request Professor Dr. Birpal Singh to felicitate Dr. Avinash Dadich, Founding Director, School of Law, Dhirubhai Ambani University, Gandhinagar, Gujarat. Thank you, sir. I would request Dr. Seema Srivastav to felicitate Professor Dr. Kanhaiya Ahuja, Head, School of Economics, Delhi, Devi Ahilyabai University, Indore, Madhya Pradesh. Thank you, ma'am. I would now request Professor Dr. Birpal Singh to felicitate Vice Chancellor, sir, Professor Dr. Surya Prakash. I request Dr. Seema Srivastav to felicitate and welcome Professor Dr. Birpal Singh. Request Dr. Pooja to felicitate and welcome Dr. Seema Srivastav. I request Abhishek Negi to please, sir, to please felicitate and welcome Registrar, National Law University. I request Dr. Manish Yadav to felicitate and welcome Chief of Examination, Lieutenant Colonel Manish Bahuguna. I request Dr. Pooja Kiawat to welcome Professor Dr. Raka Arya. I request Dr. Pooja Kiawat to welcome Dr. Padma. you. To formally start the ceremony, I would now request Professor Dr. Birpal Singh to deliver a welcome address. Dr. Birpal Singh is a professor of sociology, has over 25 years of teaching experience. He has working experience in national and international projects, including UNDP, NLIU, Ministry of Justice, Government of India. As a coordinator, he has conducted 10 training programs on law related to women and children. Over to you, sir.
Thank you, Saubhagya. Respected Chief Guest, Professor Dr. Devendra Singh, Vice Chancellor Dr. B.R. Ambedkar National University, Sonipat, Haryana, Professor Kanhaiya Ahuja, Professor Ram Singh, Professor Prasad Rao, Professor Avinath Darij, Registrar, Professor Dr. Raka Arya, ma'am, Professor Dr. Kundaiya, Professor Dr. Egan Srivastav, and the support pillar for all activities at NLIU, our own beloved Professor Dr. Surprakash Sir, the Honorable Vice Chancellor of National University, and the force behind the success of any such program, the dear students, participants, a very good morning to all of you. On behalf of the organizing committee and on my own behalf, I extend a very warm welcome to all of you at this August gathering. So far this conference concerned, we already conducted one national conference through online mode way back in 7th December 2020 on the topic, the interplay of law and economics in the society and policy making. This is the first on-campus international conference on synergies of law and economics, pathways to Viksit Bharat 2047, which is being organized by the Center for Law and Economics and Center for Tribal Studies and Research at the National Law University, Bhopal. At this moment, and we also our online, okay, online resource person, Professor Dr. Thiago Almeida, Professor of International Economic Law, lawyer and specialist at the Development Bank of Minas Gerais, Brazil. Sir, we welcome you at this conference. So at this moment, it is important to acknowledge and express our heartfelt gratitude to the esteemed sponsors and knowledge partners whose support has made this conference possible. By welcoming them, we are honored to have the government of Madhya Pradesh and Raj Niti Ayog as our key collaborator in this juncture. A premium policy think tank of the government of India plays a pivotal role in catalyzing economic development and fostering cooperative federalism through proactive state government involvement. Their partnership symbolizes a shared commitment to advancing India's development agenda, especially toward the vision of Viksit Bharat 2047. Among our distinguished knowledge partners is the GNLU Center for Law and Economics, recognized for scholarly excellence and impact. They have extended their support for this conference and offer the prestigious GNLU Journal of Law and Economics, a Scopus Index publication to the best research paper presented in this conference. So you have a chance to be published your paper in this Scopus Index Journal. It is found worthyful. We also gratefully acknowledge SSC Online, a leading platform in digital education and exam preparation, who support initiate the academic engagement of this conference. Additionally, we welcome and thank the both way Dilip Bilkan, a pioneer in infrastructure development and public-private partnership, embodying practical strides toward India's infrastructure growth. Last but not the least, Erudite Legal, a Delhi-based law firm renowned for its commitment to legal excellence and reform, joins us as a distinguished partner contributing to the integration of legal expertise within developmental frameworks. Together, these organizations form the backbone of this conference success. Their diverse strengths and shared vision empower us to explore innovative synergies between law and economics that will pave the way for a resilient and progressive India. Thank you all for your invaluable support, Jai. Thank you all.
Thank you, sir. Next in line is Dr. Seema Srivastav. Dr. Seema is currently serving as an assistant professor of economics and chairperson of the Center for Law and Economics at National Law Institute, University, Bhopal. With over 15 years of teaching experience, she brings extensive expertise in law and economics, public policy, regional development, and gender budgeting. Her research and teaching explore the critical intersections between legal frameworks and economic theory, emphasizing how policy design and economic institutions can promote equity, efficiency, and social welfare. I request Madam to introduce the conference to the House. Thank you.
Thank you, Subhagya. Very good morning to honorable dignitaries, esteemed guests, respected colleagues, dear participants, and all the representative of our sponsors, knowledge partners, and media partners. It is a privilege to welcome you all to the International Conference on Synergies of Law and Economics, Pathways to Viksit Bharat 2047, organized by the Center for Law and Economics and the Center for Tribal Studies and Research, the National Law Institute, University, in collaboration with Madhya Pradesh Rajya Niti Aayog. This conference is a timely and vital dialogue on how the dynamic interplay between legal frameworks and economic principles can guide India's journey towards becoming a Viksit Bharat by 2047. The theme embodies our collective aspiration to explore how law and economics can together shape inclusive growth, sustainable development, and effective governance. This two-day conference includes paper presentations and panel discussions by national and international experts, fostering open exchanges on contemporary challenges and innovative legal economic solutions. Our inaugural panel discussion will set the tone with the theme, Strengthening Legal Policies for Resilient Economy. This session will address urgent reforms, resilient policy frameworks, and innovations needed for India's economic growth and stability. On the second day, the panel focuses on the role of law and economics in achieving sustainable development goals. Here, experts will deliberate how law and economic insights can align to fulfill the sustainable development goals, including theme of inclusive growth, social justice, sustainability, and institutional innovations. The dialogue will bridge theory and practice, examine best practices, and regional lessons for achieving transformative sustainable progress. In addition, the conference will feature 6 technical sessions, during which participants will present their research papers on a wide array of themes encompassing the diverse intersection of law and economics. Technical session first, titled Legal Reforms and Empowerment and Growth, examines the interplay of poverty, tribal empowerment, labor rights, and for more such themes. Papers will focus on bridging the gaps in justice and fostering legal empowerment for marginalized groups. Other sessions will focus, technical sessions will focus on expanding our horizon, covering economic justice, judicial reforms, data governance in the digital economy, policy shifts in global trade and diplomacy, and legal pathways for inclusive growth. The discussion will range from cyber law to intellectual property, from village-level justice reforms to the benefits and risk of globalizing markets, reflecting the multifaceted partnership between law and economics in shaping our nation's future. Our panel discussion and technical sessions promise rich debates, solution-driven research policy, insights that will push the frontiers of law and economics towards a Viksit Bharat. We expect to have 40 presentations in our conference. I thank our honored guests, distinguished speakers, scholars, and students for their presence. Let us move forward together on the vital journey of collaborative inquiry and nation building. Thank you very much and welcome once again.
Thank you, Madam. Next, we have Professor Dr. S. Suryaprakash, Vice Chancellor, National Law University, Bhopal. With over 30 years of academic experience, Sir has served as Vice Chancellors of two National Law Universities, including Damodaran Sanjeevan National Law University, Vishakhapatnam, and founding Vice Chancellor of Maharashtra National Law University, Aurangabad. Sir is a prolific writer and wrote on several contemporary issues. His work on bonded labor and social justice was published in 1990. He is also author of Turning Point, The Story of Law Teachers, the biography of Professor N.R. Madhav Menon, which also is the story of National Law School movement in India. He has edited two books on critical issues on international commercial arbitration and perspectives on mediation. His recent publications include Remember Martyrs of Indian Freedom Struggle, forwarded by Sri M. Venkataya Naidu, then Vice President of India, and Constitution and Composite Culture, a practical guide to legal methods and legal research. He wrote 35 articles on various subjects including bonded labor, child labor, trade unions, sexual harassment of women at workplace, Indian judiciary, plea bargaining, mediation, international commercial arbitration, etc. He also did projects for DFID GVT on interstate migrant labor, involved in report writing of Project on Access to Justice for the High Court of Madhya Pradesh. Professor Surya Prakash prepared the Manual on Health Laws and Compendium on Agriculture and Allied Laws for the state of Madhya Pradesh. He is a founder editor of Indian Law Review, Law Journal of NLIU Bhopal. Professor Surya Prakash was invited by the State Department, USA, under the auspice of International Visitor Leadership Program to study US judicial system in 2010. A recipient of University Prize V.N. Dikshitilu Award for securing the highest marks in labor laws, he later earned his PhD in law from Behrampur University, Odisha also. I feel short of words and time to introduce him. Now, I request Sir to please address the gathering.
Thank you, Saubhagya. Good morning to all. Chief guest for today's program, my friend Professor Devender Singh, Vice Chancellor, D.R. Ambedkar National University, Sonipat, and the other dignitaries, Professor Ram Singh, Director, Delhi School of Economics, Professor Kanhaiya Ahuja, Head of Economics, Devi Ahalyabai University, Madhya Pradesh, Professor Avinash Dadich, Founder Director, School of Law, Dhirubhai Ambani University, Gandhinagar, and my friend, Professor Birpal Singh, co-patron of okay. And Professor Dr. Thiago Almeida, Professor International Economic Law and Lawyer, Specialist at the Development Bank, Bank of Minas, and Dr. Seema Singh, Seema Srivastava, Birpal Singh के बाद Seema Singh हो गया, and my old colleague, Professor Kondaya, Professor Prasad Rao from Andhra University, and many other professors of economics. I hope there are some legal luminaries like my old friend, Professor Yogen Srivastava, and because this is a mixture of synergies of law and economics. Because my dear student friends and participants, my entry, or it would be a misadventure if I speak about economics. So it would be safe for me to speak on law. And because the title indicates synergies of law and economics. So synergies means togetherness. So we're adding 1 plus 1. So it will be a symbiotic relationship between law and economics. When we are speaking about law, the first law of the land, it is, how many of you are students of law? Oh, then very good. I have the majority. But under the leadership of Professor Seema Srivastava, we are going to learn some economics also. So, I would like to introduce you about a law, particularly for those economists. And you can easily identify this book. I am not waving this book for any other purpose, but for quoting certain provisions from this book. So normally, when we speak of the Constitution of India, people think that Constitution of India belongs to the persons of law, lawyers, judges, law students. No. It is for all Indians. Because the Constitution starts with the people of India. That means everyone, every citizen of India must know about the Constitution. So with this basic premise, I would like to speak a few words. Then I will connect law and economics. So there are so many laws. There are economic laws, there are labor laws, there are family laws, there are IPR laws, copyrights, trademarks, and there are so many. The list itself will be very long if we merely take the title of the laws. But Constitution is the mother of all laws. So all laws, they should flow only from the Constitution. So no law could be contrary to the provisions of the Constitution. So now, how Constitution deals with economics? Normally, this we never discuss in the classrooms. We discuss about preamble. Preamble is a part of the Constitution or not, then fundamental rights, and then directive principles, and then powers of the President, central-state relations, so on and so forth. But what is the relation? The first steps to discuss synergies of law is with the Constitution. Are there any economic aspects in the Constitution? Do the Constitution deal with economics? How many of you say yes, and how? Where? Where there is a reference of economics in the Constitution? Preamble. Fairness. Huh? Right. Okay. So, you will find economic justice. So, the Constitution, the preamble speaks about we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to achieve all its citizens justice, social, economic, and political. So here I would like to discuss only about the economic justice. So one thing is confirmed that the Constitution of India speaks about economics, that is the economic justice. And then how to achieve this economic justice? Whether any policy was given, when any principles are given, and how to achieve the economic justice. Because social justice include economic justice. And political, what the preamble says, justice, social, economic, and political. To achieve political justice, there is a mechanism, that is the Election Commission of India. There will be a parliament, there will be assemblies for different states. So, there are means and institutions are established how to achieve the political justice. And what are the institutions established to achieve economic justice? How to achieve economic justice? And where it is laid down that this is the way, this is the path to achieve economic justice. Hmm?
Article 39, clause A and D.
Hmm.
Equal distribution of resources.
Acha.
Concentration of wealth.
Concentration of wealth. So how to achieve this? And merely because it is mentioned in the directive principles of state policy, wealth will be distributed equally to all in the society. You are right. That there is a clause which speaks about that certain principles of policy to be followed by the state, that the operation of economic system does not result in concentration of wealth and means of production should be to the common detriment, right? Then how to translate? So if you look at part 4, Directive Principles of State Policy, it gives it promotes the economic justice. So, and how? Merely, you want to say something?
So the Planning Commission and our Niti Aayog be one of the institutions through which this implementation of these provisions happen?
Partially right. So, we should know the part 4 speaks about, I am not going to read everything. The provisions contained in this part shall not be enforceable in any court, but the principle therein laid down are nevertheless fundamental in the governance. So please remember, these directive principles of state policy, which promotes, protects the economic justice, they are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So how directive principles of state policy are implemented? These policies, they have to be transformed or translated into laws. That is, the parliament has to make law giving effect to the provisions of the directive principles of state policy. There are also other provisions in the directive principles of state policy, like uniform civil code and other things, which I am not touching. I am speaking only about the principles of economic justice. See, right from Article 38, that is to secure a social order for promotion of welfare of the people, and 39, there are so many things. The policy of the government should be particular towards securing men and women equally adequate, that is Equal Remuneration Act 1976. The ownership and control of material resources should be, that is PSUs, and the operation, it shall not be concentration of wealth in few hands, and equal pay for equal work, health and strength of workers, men and women, tender age of children. If you look at whole gamut of labor laws, that is the Factories Act and the protection of women, and there are so many labor laws protecting the health and childhood of the workers, and provision for early childhood care and education, promotion of educational and economic interests of scheduled castes, etc. So all these are economic laws, and protection of monuments and places, other things. And Article 57 speaks about duty of the state to raise the level of nutrition, standard of living, and 43 speaks about living wage for the workers. Living wage. So what are the wages? How? In one article, the Constitution speaks about the state policy should not be in the concentration of wealth in few hands. And how? By giving living wages. So in the ladder of wages, the lowest is the minimum wage. Next higher level is fair wage. And normally the highest wage paid in the developed nations is the living wage. So the Indian working class, we are struck with the Minimum Wages Act. And we boast ourselves that ours is the fifth largest economy and fourth largest economy. Already we are marginally, there is some gap between India and Japan, the fastest growing economy. And in spite of this, so what I would like to tell you is that these are all the economic policies which are expected to translate into laws. And here, I would like to bring to your notice one most discussed and debatable issues, because we have learned economists. Normally, those who are experts in law, we call them as jurists, and we have the noted economists here. Now the debate and discussion is about freebies. And now in the Bihar elections, one party declared that we will provide 1.5 crore jobs. 1.5 crore jobs. And another party declared yesterday, we provide 1 crore jobs. Kahan se aayega 1 crore jobs? What is the industry? The most advanced industry which is providing maximum employment, the IT itself is in doldrums. And how to provide 1 crore and 15,000 rupees per child for women, or for so many freebies. Is there any provision in the Constitution? And some time back there was a discussion when there was some petition before the election commission says that it is the duty of the parliament to restrict the freebies. And parliament says that no, it is not for us, it is for the Supreme Court. And Supreme Court says that no, it is not our duty, it is for the election commission. Now who will decide on these freebies? And because of these freebies, the government is providing the rice, wheat, and 1 kg oil, 1 kg sugar, and thrusting money in the pockets of the people. Now they are not going for work. In spite of 150 crore population, in villages and in some places, it is becoming very difficult because everything is coming. Then why should we go for work? And it is adversely affecting the economic output of the nation. So, is there any provision which speaks about freebies in the Constitution? A simple question. Of course, with economists, we also have political science specialists. Yes, there is a provision in the Constitution.
Article 282, state governments can provide grants for public purpose.
Grant is something different. Freebies are something different. If for a particular purpose, now there is a cyclone and there is a loss of crops. Suppose if the government gives some subsidy or some help to the farmers, that is undeserved want. That is, which is not expected. So, the makers of the Constitution, they are conscious about the welfare schemes. So, under Article 41, they have clearly stated that, and I am not reading the whole article, just I am reading only the provision to quote. and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. So, under the welfare schemes, where the state could provide some public assistance or some economic assistance to the people, it is in cases of unemployment, you give some unemployment allowance, old age pensions. So whether he has worked, he is an employee or not an employee, agriculture worker or a coolie or whatever may be. So some social assistance, giving pension to the old age people, 60 plus. It is stated in the Constitution. Sickness and disablement. Suppose unfortunately, there was an accident, just like what has happened in Kurnool. Some people, they become disabled, train accidents. Okay, you can pay some compensation or sickness and disablement, and in other cases of undeserved want. So where the people, they were subject to certain economic incapabilities. Suppose just now, Montha cyclone, which devastated the coastal Andhra Pradesh and then Odisha, parts of Odisha, and even Telangana also. The farmers have lost their crops. So the government may give some financial assistance in such cases where there are earthquakes, where there are floods, famines, undeserved want. So these are not the calamities which the people have invited. These are the calamities, and these people, the citizens, they are subject to some economic loss. So in these matters, the state can give some economic assistance. So strictly by going the Constitution, what are the where the state could extend the welfare measures? They are for unemployment, old age, that is old age pensions, sickness and disablement, and in other cases of undeserved want. So my friends, when we are discussing about synergies of law, the first law that we have to discuss, and the first law that we have to look through the lenses of economics is chapter 4 of the Constitution of India, which speaks about the economic policy of the state. So in fact, the directive principles of state policy is the People's Manifesto, because the Constitution starts with "We the people" and dedicated to the people. So it's the people of India has given a manifesto to the political parties, to the state. You have to govern the nation in this way. And unfortunately, no one has much time to look into the Constitution, and the unlimited freebies, the unlimited competition among the political parties to give more and more, more and more. It is whose money? It is our money. It is the taxpayers' money. It is the taxpayers' money, but we are not questioning. I am not speaking about any political party. So my friends, let us discuss and debate the economics through the economic policy laid down in the Constitution of India. This is an unending topic. Again, I will speak during the time of valedictory. Thank you very much for your patient listening.
Thank you, sir. Next, we have an address by the guest of honor, Professor Dr. Thiago Almeida, who has joined us virtually. He is a professor of international economic law, lawyer and a specialist at the Development Bank of Minas Gerais, Brazil. His research interests gravitate towards law and economics, health economics, and public policy, in particular, the unintended consequences of public changes. Sir, we would like you to address the gathering, please.
of critical minerals between law and economics. So, the beginning of this presentation, and this is part of my postdoctoral research that started in Brazil, and now I'm at the University of Amsterdam. It's about what is critical minerals and why an emerging perspective of the global south is important today to talk about critical minerals. When you talk critical minerals, and for the other countries, an example as Brazil, we not use the term critical minerals, we use the term strategical minerals. This is the minerals essential for energy and digital transitions. In order to have solar panels, electric batteries, electric cars, wind turbines, you need a special kind of minerals that now it's labeled, particularly for United States and EU, European Union, the name of critical minerals. But the critical minerals today are being found not in the north, or the global north, but in the south, in the global south mainly. Especially you can find that in Brazil, in China, in India, Indonesia, and in other parts of the world. That's why those minerals like lithium, cobaltum, tantalum become so important today. They are part of this new supply chain or new manufacturing for these new technologies that are today the most important technologies for the energy and digital transitions. In order to have semiconductors, chips, solar panels, we need to have access for those minerals. That's why we have today critical change in all trade and investment policies all around the world. And critical minerals or strategical minerals became a central part of the discussions today. And now we can see that like Brazil and India share the same reality regarding trade relations today as 50% of tariffs against the United States. We can see that minerals is also part of the discussion because we talk about these up-to-date new technologies. So critical minerals or strategical minerals will be the central part. And today, critical minerals can be described in three different dimensions. The first of one, as we're talking now here, as the dimension of a climate agenda. So you need those minerals to energy and digital transitions, for solar panels, for wind turbines. So critical minerals is essential part for a global agenda for climate change. But there are conditions about this because we talk about mining. Although they're using the last part for solar panels, at the beginning there is mining. So there are some conditions regarding labor, regarding social and environmental impact on those minings. That's why the first dimension of critical minerals. The second dimension that became not only in law, in international law, but came to the economics is trade. Today, critical minerals that also encompasses hard earths are part of a discussions today for new surge of tariffs. Brazil, India got 50%. Indonesia got also the surge of new tariffs. And also we can see in this month, in October, there are lots of discussions between United States and China regarding the new tariffs and the access for our hard earths. If you want to have access for those minerals, those special minerals for semiconductors, there are the discussions today regarding can you make like new trade deals about those access for those minerals. And together with this, we see these unilateral measures in trade and investment, this new surge of imposing tariffs by the United States to almost all other countries in the world. That came in the same level because there is an absence of a discussion about trade inside the WTO, World Trade Organization. Since December 2019, there is no decisions by the appellate body in the WTO. And Brazil and India are the major powers as developing and emerging economies inside the WTO. There is no possibility to have legal decisions binding decisions in trade inside the WTO. So some countries are resorting by unilateral measures and abolishing many positions, many trade rules regarding the same treaty of partners and trade partners. There are a lot of now discrimination in trade, and this distortion in trade can be resolved in different ways. How you can now navigate today in commerce and the flux of investments today. So this is the second dimension regarding trade. So critical minerals and hard earths are also part of the discussion today for trade. And you can see that the last 2 days before, United States and China is not a deal, but this is a truce between access for hard earths and not have 100% of new tariffs, right? This is the second dimension. So the third dimension is about strategic and defense. Today, critical minerals and hard earths is also entangled together with arms race. In order to have drones, in order to have digital technology using for new kinds of digital war, we need to have access to those minerals. And that's the main important discussion. And you see, in this month in Europe, they start to call this hybrid war. The drones came into all the European continent. They accused it by Russia, but there is no 100% sure. But this came with the possibility to have access to use those minerals to the war. So that comes the third dimension about using those special minerals today. So it's climate, it's trade, and now it is strategical or defense. So this new kind of war today is a war of drones using those minerals for semiconductors and ships. And then how you can navigate this and these new differentiations, new trade relations. So those are the three dimensions of the critical minerals, and you can using these three dimensions to understand the policies and the legislation regarding access for critical minerals. And that's why the second part of my brief presentation here is it's about how can you put an emerging perspective of the global south regarding critical minerals. This is my central part of my postdoctoral research here in Amsterdam and in Brazil. Why? Because here in the global south, as in India, as in Brazil, in other parts of the global south, there are those minerals. And you can use those minerals as a measure or as an instrument, as a tool for development. And usually, when you read like the Critical Raw Materials Act of the European Union, the CRM Act action detail how to have access and special access for those other countries outside EU, and using also some financial instruments with the European Investment Bank. And recently they said it's one of the major topics, the major policies of the European Investment Bank for access for those minerals. But they use the expression access for those minerals, and they're not using the expression about how to promote better development. And they're not put together with the Paris Agreement. If you look closer to Paris Agreement and the Article 9, there is a discussion about climate finance, how developed countries can assist developing countries in mitigation and adaptation in climate change. And then we move forward through the Article 10. Article 10 said about technology transfer for the developing economies. And Article 11 for cooperation. So the emerging perspective, looking for the Paris Agreement and how we can promote development for all the parts of the world. And the emerging perspective, as now we have the opportunity to share here our thoughts, like in Brazil and India, is to see that we cannot have the same understanding of international economic relations today in the 21st century as the same as before, 20, 13 years before. Today, there are other arrangements or the forums or the international organizations that are completely different from in the 80s and the 90s. Today, we talk about BRICS or BRICS Plus. We talk about G20, not G7 anymore. So in order to have those discussions about economic relations or economic stability in global terms, we need to consider that we cannot discuss access for those critical minerals, development, economic stability without putting China, India, and Brazil together in table to discuss this. That's why this is an emerging perspective. The emerging perspective puts BRICS countries, G20 countries all together in the table. That's why it's completely different. And that came after the, the financial crisis of 2008, the pandemic crisis, and then now in the more fragmented world in terms of law and trade, we see that critical minerals is one of the topics that emerging economies like in India and Brazil can have a better and a broad participation, because we have not only the minerals but the possibility about technology. India, as mentioned here before in the before presentations here, has a spectacular position of technologies, of new technologies, and how you can use those access and to promote development and to access to the better countries. So we see that today that it's not only access for minerals, but the manufacturing of those minerals that are part that help now that is happening not in the global north, but also in the global south. But still today, when I discuss about the emerging perspective, there is still some fragmentations and the lack of coordination between emerging economies. India, Brazil, Indonesia, they have to be more close together. And you can see here now in October, there are the agenda of the ASEAN economies and the APEC economies now. So today, the world all discussing the international trade relations and investment relations in Asia now. So it's the moving the axis of the center of development from the Atlantic to the Pacific Ocean, which means that the Asian agenda today in this month becomes so relevant. That's why the emerging economies has a special path, has a special importance today in the discussions of trade and investments. I'd like to finalize my conclusions here to demonstrate that critical minerals per se is not important as long as we need to combine the access of those critical minerals with the new technologies of energy and digital transitions. And see that we not only talk about energy, but also digital transitions, digital access for those technologies, because they are together. And then I give you a practical example. In order to talk about artificial intelligence, you need data centers to process all those data. And the data centers today are mainly in the United States, Europe, and China. So India also has a surge of new data centers, but to put those data centers processing is still today using fossil fuel energy for data centers. So you are burning fossil fuels in order to have data centers and then artificial intelligence. So that's why digital and green technologies are together. We need to have artificial intelligence, we need to have data centers, but we need to look for how to process data centers. So we need to see renewable using of an energy and other resources as minerals and water. That's why you can see that's one of the dimensions of the critical minerals. Climate agenda, and then the other is trade, and the other is strategical / defense area. So those three dimensions work together with the new position of the emerging economies. So thank you for this quick presentation here. I don't like to highlight these possibilities that there are today with the emerging economies and how India and Brazil, and especially a few weeks before, President of Brazil, Lula, came to see Narendra Modi here in India too, and to show that there are new possibilities for new trade and investment agreements between those two countries. Thank you all, and a special thank you for Professor Abhishek and Professor Chirag Balyan for this invitation as a guest of honor. Thank you so much for being here, and I wish you a good conference for you in the next days. Thank you so much.
Thank you, sir. Next, we have Professor Dr. Ram Singh as a guest of honor. Dr. Ram Singh is the director of Delhi School of Economics, University of Delhi. Sir is a leading scholar whose work in economic theory and public policy has refound how we understand governance and growth. So please.
Uh, Thank you. Very good morning to all of you. Professor S. Surya Prakash, Vice Chancellor of the University. Professor Devender Singh. Professor Kanhaiya Ahuja. Professor Tiago Almeida. Professor Avinash Dadich. Dr. Seema Srivastava, esteemed colleagues from the university and other academic institutions in the country, dear students and guests, thank you for having me as a part of this conference and as a part of this august panel to share my views. I want to start by conveying my appreciation for this serious initiative that Professor S. Surya Prakash and Dr. Seema Srivastava have initiated. This is going to serve students very well. Students present in this room, be sure that that to the extent you bring economic reasoning, economic dimension to your learning process at the university, it's going to serve you very well in your career path, whatever dimension of your profession you choose. This I say based on my experience with other law university, Gujarat National Law University, and today we have stalwarts, two, Dr. Ranita Nagar, Professor Ranita Nagar, and Professor Hitesh Thakur. They initiated a process very similar to this more than a decade ago. And whatever they have achieved in the process is quite remarkable. I just want to mention only one of the several achievements, which is that their students of the Law University, Gujarat National Law University, have been making it to the top law schools world over, in the US, Chicago Law School, Yale Law Schools, and also in Europe. And I think their training in economic analysis has helped them a great deal in making it to leading schools. So you have Professor Surya Prakash, Dr. Seema Srivastava, you have started something very serious. I don't want to pitch economics as a main driver of legal training and understanding, but it is an important, crucial, missing dimension that a gap that you will be filling. You will be training lawyers, judges, and professors through this process, and you will be harnessing, in the process, you will be preparing this country to harness synergies and complementarities between economic reasoning of law and economics. Then I had the benefit of listening to the speakers before me, and I decided to change the topic I want to interact with. I will reflect what Professor S. Surya Prakash and other speakers have mentioned about me. I want to, so there have been our law professors and our judges are trained to look at constitutions, to look at judicial pronouncements through the lens of constitution. That's the right thing to do. That they are also told that this is, for example, Supreme Court of India and high courts. They look at themselves primarily as constitutional courts, which they are. But their mandate is to do more than just interpreting whether a particular statute, a law, an act is in the spirit of constitution or not. So they are multidimensional courts. As a society, we expect them to think beyond constitution. But if we think only from the lens of constitution, we have been able to achieve something remarkable. So there were times in our economic history post-independence where Indian economy, society was dominated by state. State control was paramount. State control over property, state control over production activities, nationalization of banks, nationalization of property resources, nationalization of mineral, the previous speaker alluded to. The same constitution was used to go for privatization of same resources. Banks that were privatized under the same constitutions that were nationalized under same constitution in 1969 and around that time those institutions are now being privatized. And this process, moving from one pole to the other pole, is possible under the same constitution. On the issue of property, we started right to property as a fundamental right. Then we diluted that right to a mere constitutional, then to a mere legal right. Now, Supreme Court of India almost 1 year ago, came out with a judgment in Property Owners Association versus last year. Under that judgment, Supreme Court had said that the right to property, don't take right to property as a mere formal right. It is comparable to human right. Now, a Western scholar will look at human right even more fundamental than what we call fundamental right. Our fundamental rights are interface of what we qualify as, there are two categories of rights. One are available to every human, whether they are Indian citizens or not. Others are restricted to only Indian citizens. But world over, scholars will look at human rights even more fundamental than what we put together as a fundamental rights. All this has been made possible through same constitution. There have been constitutional amendments, but point is that as a society, as a collective, we have been able to do remarkable things. We have been able to complete the cycles and circles on property, on several issues. However, in all this discourse, the focus of legal scholars and judges have been on relationship between Part 4 and Part 3 of Indian Constitution. So the state is a state. Professor Surya Prakash mentioned Minimum Wages Act, freebies, making provisions for roads, schools, state agencies, state as a government executive, uses Part 4 of the Constitution to advance whatever they want to justify what they are doing. But that immediately runs into provisions of Part 3 which is fundamental rights. So for the most part, during last 7 decades, the debate has been judicial pronouncements where judiciary has tried to reconcile or resolve the conflict arising between these two crucial parts of Indian Constitution's fundamental rights on the one hand and directive principles of the state policy on the other hand. In this discourse, and our institutions have done a great job, courts, legal scholars, law professors have done a great job in reconciling the differences between the two parts so that economic developments, welfare programs can go hand in hand with the protection to fundamental rights. In the process, however, we missed out on economic efficiency of resources that are in private hand. The issue has been mostly, our preoccupation has been if state government or branch of state government or central government does something that infringes upon fundamental rights, how to resolve that. Problem is that whenever disputes are primarily private, either between two private individuals, entities, or the government on one hand and private entity on the other hand. Those disputes also, Indian judiciary tends to look at those issues through the lens of Indian constitutions, mainly through the lens of right, justice, rights. But then there's an argument that there is a Indian judiciary, Indian law processes are mindful of economic dimensions also, because justice, and there is a provisions for economic justice also. Problem with economic justice is that we can end up doing something that seem to promote economic justice, but in the process we can end up harming the same people, same constituency, same economic social strata we seek to protect. The implications of what we do to protect a particular set of Indians, that it can actually boomerang and harm them. I give some illustrations. One comes from property rights. So when we enacted eminent domain laws in our country, we gave right to people, farmers, property owners, that if they are unhappy with government-provided compensation, they can go to court. And court-provided compensation cannot be below government-provided compensation. On face of it, such a protection that, if government takes away your property, gives you compensation, you feel that you have been inadequately compensated, you have right to go to court, and court can only increase the compensation. On face of it, it looks in a law, a protection in favor of property owners. But the same law has led to an outcome where everybody affected by land acquisition, property acquisition under eminent domain, ends up going to court. Why do they go to court? Government agencies, government officials know that they are going to go to court. And courts can only increase compensation. Therefore, their low pitch, their offers are low-balled. They make minimum possible compensation knowing that these guys are going to go to court. This principle is known in legal tradition as prohibition of reformatio in PS, that you should be able to appeal without fear. That's a justice, that's an important justice consideration. But in the process, we end up forcing our citizens that they have to incur litigation costs. They have to waste their time, they have to make rounds of courts before they get what is their due. Similarly, when we enact laws like to provide minimum wages and what we call, old age pension or unemployment pensions. Point is that such intervention, such protection, such economic justice is granted under the preview of Indian Constitution. It cuts both ways. Today, it protects the beneficiary. But at the same time, it makes labor, it has two implications for labor force participation, for us to have incentive to work. One is that it increases the cost of labor. Other, it reduces supply of labor in the economy. As a consequence of both, we see a lot of mechanization in industry, in services, and also in agriculture. And who loses out if there's excessive mechanization? It's the labor. It's the unskilled labor. It's the set of people we are aiming to protect. They end up as a loser in the process. So my submission is that when we go for such exchanges, we have to keep in mind that any legal intervention, any judicial intervention, it cuts both ways. And we have to be mindful of that. Our judiciary tends to be oversensitive to their sense of rights and justice. When they interpret the private agreements, let's say sale deeds over properties, when they interpret contract terms, they tend to be guided by the issue of, they show oversensitivity to the issue of justice. To give you another illustration, most Indian cities have Rent Control Act. Rent Control Act was, its intent is to protect people who do not have house property, who are tenants. So they should be protected, otherwise fear was that the property owners will charge excessive rent and thereby exacerbating inequalities. What is the outcome? Outcome is Property Owners Association versus State of Maharashtra judgment delivered by Supreme Court in 2024. Underlying that judgment, the root cause of that judgment is Rent Control Act in Mumbai in this case, but the same story gets replicated in most cities. Because of Rent Control Act, both sides, tenants do not have property rights, but owners' right to property gets diluted because you don't have freedom to choose who will live in your property and for how long. Since you do not have right over your property, your incentives to invest in your property upgradation come down. Therefore, those buildings that should have been 20, 30, 40 stories building in Mumbai, they remain 2, 3 stories building even today. They have become dilapidated. They have become unsafe. They have become unsafe. Property owners do not want to invest because they cannot increase rent. If they cannot increase rentals, why should they invest? People who are living in these properties as tenants, they anyway don't have rights or incentives to invest in those property upgrades. Outcome is artificial scarcity of land in Indian cities. Outcome is shortage of houses in Indian cities. Outcome is litigation between property owners and the state. And then judiciary's precious time is wasted in the process. So now, but Supreme Court in this judgment, which is, in my view, is a sequence. It's in the same league as Keswananda Bharati and Minerva Mill judgment. The 2024 judgment belongs to the same league, because it's so central, property rights and also ability of the state to infringe on fundamental rights are as central to this judgment as they were in Keswananda Bharati and Minerva Mill. But even in this judgment, the focus has been primarily on, the issues have been framed as issues of fundamental rights versus what state can do. They are losing sight. They have, even though there are extensive paras mentioned in the judgment, how rent controls have created the problem, but the root cause we are missing out. So through such dialogues and by training students the way we will be training through these processes, we can hope that we will have more sensitive scholars, professors and judges who will be mindful of. I have several other things to say, but mindful of time, I will stop here. Thank you so much.
Thank you, sir. We regret for the short timing we had. Next speaker, as a guest of honor, we have Professor Dr. Kanhaiya Ahuja, Head School of Economics, Devi Ahilyabai University, Indore, Madhya Pradesh. Sir is a professor and head of department, School of Economics, Devi Ahilyabai University, Indore. He has successfully guided more than 20 PhDs and 36 MPhil research scholars. He has authored 8 books and published over 100 research papers in reputed journals. Over to you, sir, please.
On the dais, we have Honorable Vice Chancellor, Professor Surya Prakash sir, Professor Devendra Singh sir, my colleague, my very good friend, Professor Ram Singh, Professor Avinash sir. Then we also have Professor Birpal Singh, Dr. Seema Srivastav, and Ms. Subhagya. Distinguished guests and students of law and other streams, Thank you so much. First of all, I would like to congratulate you for hosting such a wonderful conference on a very, very important topic, which is very, very relevant, you know. I'm not a student of law, but I'm a student of economics, so I'll talk more about economics because most of the students sitting here are law students, so I'd like to teach them a little bit of economics, you know, because if you teach me law, won't be able to understand that, you know. So I'll just recall one incident. A subprime crisis took place in 2007-8 in America, and all US was on the roads. The banking system collapsed, and you know, everybody was expecting, because we have a lot of Indians abroad and a lot of you know, money comes from US to India, and everybody was concerned that this is going to have an impact on Indian economy. But two things which saved us. One was that Indians have a habit of saving. Whatever we earn, we just save 20, I mean, even if we earn 100 rupees, we are going to save 25 rupees, 30 rupees, 35 rupees, and that has been 35% rate has been our saving rate. Another very, very important part which saved us was that we have a very strong regulation systems. Even if we go for a loan to a bank would make our life hell. You know, we have to go through a lot of documentation. And in America, if a lady has to go for a nose surgery, the unproductive loan would be available very, very easily to her. So that is how the system is, and that is how the regulations work. So I just wanted to bring this point into for a discussion that yes, law and economics have a strong association, and if we are thinking of bringing this Indian economy to a pathway of 2047, when India is dreaming of becoming a developed nation, then I think law has to play an important role, the regulations has to play an important role. But first of all, let us understand where do we want to go, what is the path ahead. So that is what I want to have a discussion on, where do we stand today and where do we want to go ahead. If we talk about GDP size of India, it's around 3.7 trillion right now, and in 2047 we are dreaming of becoming $30 trillion. That's a huge task, and India is planning. What India is doing, that I'll come to later on. GDP growth right now is somewhere around 7%, and we are dreaming if we have to maintain this, if we have to reach this benchmark of India becoming a developed nation, then we have to go beyond 8%, 8.5%. Regularly, we have to maintain that ratio, otherwise we won't be able to come closer to that. The per capita income right now is 2,700, and what we are planning, what we are dreaming is that if we have to reach the benchmark, then our per capita income should be around 18,000 rupees to 20,000 rupees, somewhere in between that. Dollars I'm talking about. Manufacturing sector is one which has suffered the most in our country. Now that contributes only 15% of our GDP. But yes, if manufacturing sector has to go, then it should be at 25%. That's a big benchmark, and no economy can really reach that mark. I mean, our dependency has been more on agriculture. More than 50% of population in our country has been dependent on agriculture. But if you look at the sectoral composition, we have to make a lot of structural reforms so that manufacturing plays a very, very important role. And we have a target that this share of 15% reaches to 25% in the next 25 years, so that India could come closer to that benchmark. Poverty, we have been working very hard. Multidimensional poverty has been declining, and we are targeting that by 2047, India would be a nation without any multidimensional poverty mark. Unemployment ratio is something which is point of worry, and we want to keep it below 4% by 47. After that, another very, very important point, and if you look at the last couple of budgets of Government of India is playing a very, very important role, and they have been placing a very important component, budgetary component on female and youth. And what is the point of worry is that being 50% in our total numbers, their contribution as a workforce is very low. So this is one area where the government has to work if we want to come closer to the benchmark of being a developed nation by 2047, then women work participation has to play an important role, and this is where the government is concerned about. And I'll talk about the budgetary allocation later on, where the government has given a very clear mandate to that. Yes, some funds have been allocated for this purpose also. Another health indicators are the point of worry. I'll remember the COVID-19. When COVID-19 came, the one sector which was the badly exposed was the health sector. And later on, we realized that even for the smaller, very ordinary instrument, we were dependent on China. We were importing those instruments from China. And we were spending just 1.8% of our total GDP on health, and that was very low, very meager amount, you know. And if you compare this with the many developed and developing nations across the globe, then those nations were spending 15 to 16% of their GDP on health, and we were spending just 1.8%. So that was a point of worry for India. And after COVID-19, when this crisis came, the most miserable sector was the health. And after that, you'll find there had been some positive changes in the thinking of the government. The government has increased this budgetary allocation from 1.8, and now it is spending a little bit more. But still, we are far behind. If you look at the malnutrition, if you look at the many other indicators, then still that's the point of worry for all of us. And this is where the government has to really think about. Another important is renewable energy. I mean, our dependency on fossil fuel has been a matter of concern. And India has signed the Paris Agreement, where we have to make our atmosphere absolutely zero carbon free, and by 2070. And the progress which India is making is remarkable. Now we are substantially manufacturing electricity with the help of renewable and solar and wind and all these kind of energies. And our shift has been from fossil oil to renewable energy, and that's a good sign as far as India is concerned. Exports is a point of worry. But yes, if you look at the exports right now, it's around 825 billions, which we dream to take up to somewhere between $3 to $4 trillion by 2047. Now, if you look at the efforts of the government over the last 4 or 5 budgets, you'll see a very clear direction. The government is spending on manufacturing sector. Government has realized that if India has to if India has to really go ahead, if India has to pick up a path which is very conducive, then manufacturing has to play an important role. Industry has to play an important role. And that is why, if you remember last budget, they have made a national manufacturing mission where they're spending huge amount of funds under the banner of Make in India. Infrastructure push, we all know that 11.1 lakh crore is a huge amount, perhaps the maximum till date, where the government has realized that infrastructure development is the key for India to go ahead. Whatever dreams India is making, those dreams would not be able to fulfill unless we don't have enough capital funds under capital investments, and this is where the government is spending huge amount of funds. Green growth is, I told you, very importantly, the government is spending around 40,000 rupees crores on green energy, and this is another direction where, I mean, the last 3-4 budgets, you'll find very clearly that we are spending on energy, we are spending on investments, infrastructure development, we are spending on manufacturing sector, we are spending on digital transactions, we are spending on funds for women, funds for youth. Another factor, we feel so proud, Indians feel so proud, and we always say that we have a demographic dividend in our country. And if you look at the median age of in our country, it's around 28 years. Whereas America, it's around 39 to 40 years. China is still older. So it means we are still a very young nation, and we have a potential. We have a potential not in terms of only capabilities, but at the same time, if you look at this age difference, that's a big potential for a big advantage for all of us. And this is where India can take a big leap, and India can take an advantage that we have a demographic dividend, and that's going to really pay us off in the next coming years, next 25 years. So that's going to play a very important role. Now, what is to be done? That is what I'm going to focus. And a couple of areas which are very important is we have been talking about inclusive growth. And inclusive growth means we have to believe in one very important aspect, that is known as a decentralized planning. I don't know, I mean, different planning process the country has gone through different planning process, and still we believe it. What I believe is that India can really reach the benchmark if we really concentrate on decentralized planning. If we decentralized planning is not in place, then we will not be able to work very efficiently, very amicably to reach this benchmark. Another very, very important point is a woman. Woman has to play an important role. And now if you look at the last budget, government is spending huge amount of fund for women entrepreneurs. I mean, this is a very new dimension that now startups and entrepreneurs, women, the government is focusing on that particular area. If we have to reach the benchmark by 2047, then women has to play an important role. And more entrepreneurial activities have been targeted for women. And this gap, the numbers almost 50% as far as the population is concerned, but their contribution in the workforce is very low. So that is where the government has to work, that is where the society has to work, that is where we all have to work, and women has to play a very, very important role. Another very, very important aspect I told you in the beginning, the way India has progressed with respect to digitalization, that is something very, very remarkable. The world asks us how India is making so much of UPI transactions. In terms of UPI transaction, India is #1 in the world. And that is how, when demonetization took place long time back, and after that, a lot of progress took place in our country. I personally feel that demonetization, and later on, I'm not going to make a question mark on the timing and the process and implication of that. That might be a point of discussion. But overall, yes, that has put a lot of efforts, a lot of initiatives have been taken as far as digital payments in our countries are concerned, and now India stands much ahead in the world as far as digitalization is concerned. So this is where now we are talking about, if we are talking about 2047, and this is going to be a digital economy, because without digital economy, we cannot progress. And that is why, if you look at the last couple of years, Indian government is focusing on AI, Indian government is focusing on Internet of Things. These are the different, even machine learning also. These are the different technical aspects on which the government is really focusing on, and that is where, these efforts can take us to the goal of meeting 2047 as a developed nation. Another very important aspect to the health, I told you in the beginning, the malnutrition in among many marginalized communities is a point of worry for all of us. So this is where we have to think about, we have to put a lot of efforts, we have to put a lot of funds under this belt, and if human development is something which makes a nation very strong. This is where India has lagged, and this is the right time that if we are thinking of reaching that benchmark, then yes, if you're thinking of reaching that benchmark, then this is one important direction on which we have to work on. So these are the very different, a number of policy implications which are very, very important, and I hope that the efforts of economics and law integration, regulation is very, very important. The integration of law and integration of various dimensions of economics would definitely take us to that benchmark of 2047, and I personally feel that this kind of conference would involve into a lot of constructive discussion how the things can work, how this integration can work together, and how we can go ahead to the benchmark of 47. Thank you so much for inviting me, sir. Thank you, sir.
Thank you, sir. Next, we have a keynote address by the chief guest of the ceremony, Professor Dr. Devinder Singh, Vice Chancellor, Dr. B.R. Ambedkar, National Law University, Sonipat, Haryana. With over 25 years of extensive teaching experience, sir has established himself as a respected academic in the field of law. I regret calling the Vice Chancellor, sir, in the series. I would now request our guest of honor, Professor Dr. Avinash Dadij, Founding Director, School of Law, Dhirubhai Ambani University, Gandhinagar, Gujarat, to address the gathering. Sir is a Global Advisory Board member for AMS Ethical AI. Dr. Avinash brings deep expertise in AI ethics to guide the responsible and transparent integration of artificial intelligence in talent acquisition. Sir, please.
Om. respected all the senior dignitaries on dais and off the dais, all the students. My time is only for 10 minutes, and I know it happens, when things are getting late, we just want to move fast. I will speak only for, I think, on very specific issues, like learned economics. Somehow I feel the soft tension in this room that lawyers say, okay, I will talk about law, economists say, hey, I will talk about economics, and then we go home, we take lunch. To some extent, what we missed in India in last 70, 80 years, that we made our economic policies, we never invited lawyers. Same thing when we made our legal and regulatory policies, we never invited economists. Definitely political scientists and social scientists, they are always excluded from this process, especially from the law side. That's a natural reaction because we all want to protect our own home ground. We believe that constitution can solve all the problems. Economists can believe that mathematical calculation or equations can solve all the problems. Political scientists, social scientists, they believe that we have theories which can solve all the problems. But we never want to work together. Because this word synergy, it brings transaction cost. Economics is all about transactions. If you can reduce the transaction cost, it's a good economy. And if the transaction cost is very high, to do anything, that's a bad economics. It's a simple definition of economics, if any lawyer wants to understand what is economics. On the other side, law is more complex because within the legal system, we have multiple objectives. We have social, economic, political, cultural, personal, as well as public goals. So law is more complex than economics, at least I can say as a student of law and economics. But they have to work together. It's as simple as that. Law cannot, like, for example, Professor Ram, he talked about the rental, this rent control system. I think same issue is happening in almost multiple laws. Like, for example, I give you very simple example, NI Act, Negotiable Instrument Act. Very simple law. Nothing complicated in that. More than 50 lakhs cases are pending in Indian courts. And now, if you go in any country or any city, you will find that they have special courts for NI Act. Highly trained judicial officers are doing very clerical work. So the objective was to regulate this particular sector, and now we have invited another problem, that we don't have judges, enough judges, and then a good number of judges, around like 20% of judges are doing NI Act cases. Why it happened? Simple. When we were designing this ecosystem, we never thought about the economics of the check. When you issue a check, it's an economics. It's not a legal term. It's not a legal transaction. It's an economic transaction. That I give you my check, and on the assurance of this paper, I give you my services. But then it doesn't happen, you go to court. 50 lakh cases. Very simple solution is found in multiple countries. I tell you one simple example in France. Like, for example, in France, if you go to a restaurant, and if you want to pay by check, they will accept it. They don't know you, but they will accept your check. Why? Because if your check is not honored, immediately, they will give you some time, but if you are not able to respect your promise, your bank account will be blocked. Why we cannot find simple solutions in our country by the using of economics? That if 2 or 3 checks are dishonored by any individual or any company, all the bank accounts should be on hold. That sorry, you are not able to respect the dignity of this financial system, and you are creating extra burden on entire ecosystem. We have multiple problems in our country, but I believe that if, like this conference, where the lawyers, economists, social scientists, political scientists, and other, I miss, I think, the tech people in this room. I think we need to invite the tech people also because they can bring amazing solutions. Why we cannot have interdisciplinary dialogues? I really appreciate this conference. Normally, I don't go in many conferences nowadays because I'm a law professor, but frankly, I'm not a big fan of law. I believe that better solutions came from different dimensions, so I attend mostly non-law conferences nowadays. I attend tech, economics, philosophy, because I learn more from those conferences than law conferences. But I think this is the conference where Professor Birpal and Professor Surya Prakash, they have invited interdisciplinary people, and in a very interesting dialogue, Viksit Bharat 2047. I think this is a very nice initiative, and I appreciate it. And especially speaking after Professor Ram, it was very difficult because I think we must admit as all law professors in this room that how many of us can speak about economics the way Professor Ram spoke about law. I think this is the time to reflect. We don't know about economics. Most of the law professors say, sorry, I don't know about even the ABC of economics. And Professor Ram, he was talking about Minerva, Keswan and Bharti, and we were saying, wow, he's a law professor or like doing something secretive in economics. That's the beauty of economists. They always think beyond the economics. I think as a professor of law, this is a great learning for us that we should read about economics. And when I say law and economics approach, I think this is not economics. This is law and economics approach I used in my PhD thesis. It's about how to do economic analysis of laws and legal institutions while we are making any law or while we are designing or reforming any legal institutions, whether it's a court or a regulatory body, how to bring economic analysis in it. Okay, because if economics is not matching with the ground realities, that law will not happen. Like NI Act, classical example is NI Act. Everyone is loser in NI Act. No one is winning. Okay, because we never thought about the economic implications. So I believe that the purpose of law, when the professor is 8 minutes, please stop me. Professor Birpal Singh, please when 8-9 minutes, please tell me so I can stop. I have so many things to say, but it's not good, I continue. The purpose of law is nothing but bring certainty and transparency in the ecosystem. If a law is complex and creates more ambiguity and transaction cost in society, that law is not good. As simple as that. And we cannot ignore the social and cultural and human aspect. For example, few days back, government of India over the night killed $23 billion industry. $23 billion. If I multiply, it's almost like now like 2 lakh crore, or maybe 1.56, I don't know. That was a gaming industry. Very fast growing industry, 1.5 crore industry died over the night. Why? Because the gaming industry guys, they believe that whatever they are doing, whether it's really affecting society, thousands of people are dying, we don't worry. Because this is economics and this is adding the value to GDP. Professor Ram, I believe that industry also should need to understand, economists also need to understand that it's not only about economics, it's not only about economic growth. When we talk about Viksit Bharat 2047, we also need to understand that what type of growth we want. We don't want that type of growth like $100 billion or $200 billion industries, the gaming industry, where millions of people are committing suicide. We don't want that type of economy like in Western countries, they have even allowed some type of drugs to promote the GDP. I think Indian model is very unique. We are neither European or American or nor Chinese. The Indian model is very unique. The way Indian High Courts and Supreme Court intervenes in the policies, and especially the democratic ecosystem, the election ecosystem is very unique in India. We are not like US, like only two-party system. And neither we are like Europe or European Union or the China. Indian democracy is very different animal. So in this country, no government, no ecosystem can ignore the social aspects, whether it's protected by constitution or not. Constitution is a living document. Sometimes it's not enough to react. So government has to intervene. So in this country, we have multiple stakeholders. And economics can only survive in this country when it goes very well with the social fabric of this particular country. And sometimes the excited economists and high quality consultants, they presume that what is possible in Western countries can also possible or replicated in our India. I think the problem lies with the law and development approach. I request you to read a little bit about law and development approach. Now it's almost dead, but from 1950s till 1980s and 90s, that was the approach, promoted by the US, that law and development, they are connected. And from the DC, we will bring some rules, regulations, policies, ecosystem, and you implement in your country and you will grow. You will be a developed country. And it didn't happen. There was a very famous joke which I heard in Toulouse when I was in France, that one African country used to request a lot of to DC guys that, okay, please come and train us, give us more document and all these things. So DC guys got very excited about that country. And they kept sending like thousands and millions of documents, printed documents. And one day they realized that they are not doing anything. They are just receiving those documents. And they asked them, why are you doing? They said, see, in our country, we don't have papers. So when you send us paper, we use the blank side for the printing. Okay, so that is the best use of your law and development approach policy. So we have to be very careful in our country that this law and development approach, law and economics approach, which was advocated by the Western forces, and I see value in them, definitely, they have great value. Law and development approach basically talks about if you have good institutions, legal institutions, okay, regulators, adjudication process, if you have a strong ecosystem where people can enforce their contracts, if you have a strong ecosystem for dispute resolution, recognition and protection of property rights, these are the fundamentals. But what was missing in Africa and in other countries, that without understanding the political, cultural, social, historical aspect of that particular country, if you just import that rule or policy, it will not work. So lawyers are very tempted to make laws. Unfortunately, our country is driven by lawyers. I'm sorry to say, this is good for law students, but from the country's perspective, our court system is driven by lawyers, not by judges or by professors. Professors are almost missing in courts ecosystem, in the judicial ecosystem. That is very problematic. But even judges are also highly driven by the lawyer's interpretation. I think we also need to challenge that aspect. Last, not the least, but Sanjay Sanyal's speech, I think you must read very briefly. He talked about, Sanjay Sanyal, as you know, he's working in the PM Economic Advisory Council. And he said very clearly, very strong statement. Then I will stop. He said the biggest hurdle, the biggest single hurdle, the word he used, the biggest single hurdle to become this country as a developed country by 2047 is nothing but judicial system and legal ecosystem. I think this is a challenge which lawyers, professors, and the legal community should take. That as a very senior person, if saying the single biggest hurdle, not only one of the single biggest hurdle, if this is the legal ecosystem is creating that hurdle, I believe this is a great opportunity as a conference that we should really ask ourselves that are we adding value to this economic growth, or we are just creating hurdles and lawyers are making money. I think this is the question which we should really ask each other during this conference and post this conference. Thank you.
Thank you, sir. I would now call upon stage Professor Dr. Devinder Singh, Vice Chancellor, Dr. B.R. Ambedkar National Law University, Sonipat, Haryana.
Very respected and honorable Vice Chancellor, Professor Surya Prakash ji, my senior, my elder brother, under whom I am learning and getting opportunities to visit here and elsewhere as well, and having his benefit to the staff and students. Dignitaries on the dais, Professor Birpal ji, colleagues from the other universities, participants and dear students. I know my limitations. I am not only standing between the panel discussion and high tea, but also the rest of the program which is being given here. Anyway, today is the day when we are crossing the carpets. Economics going to law and law is accusing law. Very unique. So this is a carpet crossing. I will also try to do some sustainability here. I see that the law is a regulator. Now we understand that law is a regulator. Economics is the necessity. And I was a student of economics right from 10+1 to my BA final year. I studied economics as a normal subject like political science, history and other subjects. I took it normally because my economics at that time was run by my parents. And later on when I joined law college, then immediately found that most of the students reappear in economics subject. All of a sudden I came to know economics is a tough subject. And also that I entered into life, I told my father that I done PhD during this services. So I told that my 1 year salary almost consumed my PhD. PhD is a highly and this very costly affair. Then my father replied that yes, only PhD is costly affair, rest of the education is very easy. So economics is like this. But what I learned in economics very seriously is that economics is all about demand and supply. And one principle is very much dear to economics, that the demand is more, supply is less. And here comes the regulator, that is law. We are regulator, law is regulator, and if there is an insecurity in the minds of the society, the citizens and everyone, that the jobs are less and demand is more. And then you see the role of the regulator. Regulator becomes the supervisor, the overshadowing authority and everything. So the credit goes to economics. Economics is a necessity and is being everybody's need. But law is popular. That is why the seminar is law and economics. It should have been economics and law because economics is necessity, law is a regulator. Law is being accepted, law is being punishment, it provides punishment. Why we take the law as a last resort, that when the problem is not solved by anyone, when demand is more, supply is less, then law says, close the doors, call the police, that's over. Meaning thereby, law is supported by the sanctions itself. I see law and economics from many angles. I see it from the very beginning, that is the land reform days. Land was the resource, and when Pandit Nehru said in the Rajya Sabha that we are going ahead with the law reforms, and this land reforms, pan-India, it is one of the essential in the directive principle of the state policy. But the courts were on the other side. Court says directive principles are not essential. This is not fundamental. Fundamental rights are fundamental, right to property is a fundamental right. So courts were coming in the way, and then Pandit Nehru spoke in Rajya Sabha saying that the Constitution has created two chambers. Supreme Court and the other courts are trying to become the third chamber. That will not happen. So how much this Sanjeev Sanyal statement will stand and how long it will stand in presence of the mighty Supreme Court. He may be called as a contemner before the Supreme Court, and he has to change his writings. So it was the law and economics basically, because the land was considered the only source at that time. Economics has to prevail, and economics prevailed throughout. We have seen the farmers' movement recently. That was connected to this. Before that, when 2014, Narendra Modi's government came with the vision of ease of doing business. They were very much passionate about this Land Acquisition Act, of which we are speaking here, that the compensation and more compensation. And then immediately issued the ordinance, then reissued the ordinance, and third time they took back. Firmly being conveyed by the society that land belongs to us, we are the owners, government cannot make law for us. And that thing in recently being reiterated by the farmers of Punjab and Haryana, that you take back your laws, we do not need any laws, we are farmer, we are self-sufficient, we are government unto ourselves, we don't need government. Government has to eat back its own laws itself. Meaning thereby, the law has its own limitations when it comes to economics, but economics of whom? Economics of concentrated resources, of which the Constitution is saying, and Professor Surya Prakash in the beginning said that this resources should not be concentrated. If it is a GDP of 8%, it is a growth of 8%, it is an agriculture contribution to the GDP, whose contribution? Who are the agriculturists? Who are the farmers who are contributing? Is the whole lot of farmers they are contributing, or other farmers are committing suicide? We have to see it from many angles. This relationship is to be seen from many angles. We see judicial reforms, then judicial reform in itself. When it is like accusing our own house. We are teachers of law, we are producing lawyers, and what we are producing? We are producing people to fight in the courts. And they are the link between the society and justice. And how the justice is being delivered? We all know. It is not the acceptance, but it is a public truth that when a person goes to court, then mediator is the lawyer. How much a lawyer charge? The rest of the thing is the delayed justice or something that happens later on. But the first thing, they meet a lawyer, and lawyer takes the cause to the court, to the judge. And then we say that it is a costly affair. Then finally, if we do some analysis that who are going to the courts, then ultimately we find only two type of persons are going to the court. Others are not going to the court. One, those who are salaried class, they get salaries from the government, they are going to the court. This is service matters. And other is the byproduct of the economics, that is the criminal side. Those who are fighting, or there is a clash of interest in the society. These are the two categories who are before the court. Rest is the litigation, which is the family matter, which is egoistic things, or something like this. Whosoever has money, they go to the court. Otherwise people are not going to the court. Politics, most of the things nowadays are being, sometimes we see that there must be some law to eat also. Law has entered our households. Earlier there's a food, only right to food. Now domestic violence. And I think not more than 10 years it will take. It will be violence against the children. Law has already entered our bedrooms. Law is seeing everything. So we are regulated not only now into the necessities, but into the education, into the health system, and everywhere it is being seen. Governance is based on economic principles nowadays. And I can say that, not after listening to every speaker, but otherwise also, that where economics is not there. Everywhere there is economics. Everything is being commercialized. Everything is being seen from the prism of economics, from demand, supply, and cost. Everything, even relations. So in this background, if we are discussing law and economics, that is not only good for the law students, but it is good for us, for scholars as well. We can decide the cases earlier, but that is not possible. If experts start deciding the cases, most of the time it happens that if two or more checks are bounced, then automatic FIR should be there. And the account is being sealed. Then where is the court? Where is the judge? Where is the justice? Then who is doing the justice? Then expert is doing the justice. Bharatiya Nyaya Sanhita is also speaking that there should be forensic labs and everything would be done in the forensics terms. Investigation be done in the forensic terms. Then what courts will do? What is justice? Then justice shall be delivered by the experts. Justice shall be done by the computer, by the machine, or by the human being. Justice has a human rights angle also. So there are many things. There is not only technology, this is not only economics, but we have to see the society from many angles. The basic point in the society is the human face has to be saved. Economics is also harsh, law is also harsh. So sometimes we have to find the sustainability. It is not the sustainability in terms of environment law. We find that wherever we have a need, wherever we want to create the infrastructure, we are creating. Can anybody stop us? We are doing it. If we have money, we want to purchase property. Can anybody stop us? That now we can't stop the property, we can purchase the property. We understand legally that this right to property is not a fundamental right, it is a legal right. It can be stopped, but can it happen? Has it happened? It is just a change of nomenclature. Craze for the property is the same. So there are many things which need sustainability, not the environment sustainability, but this subject also, this relation between law and economics also needs sustainability. This seminar will contribute towards that sustainability, and this sustainability, with this hope and trust, I rest my case. Thank you very much.
Thank you, sir. I request Professor S. Surya Prakash, Vice Chancellor, National Law University, Bhopal, and Dr. Birpal Singh to felicitate our knowledge partners, Center for Law and Economics, GNLU, requesting Dr. Anita Nagar and Dr. Hitesh Thakkar from the same institute to receive the token of appreciation from our end. Thank you, sir. Marking an end to this inaugural ceremony, I now request Dr. Padma Singh, convener of this conference, to present a vote of thanks to the August gathering.
Thank you, Saubhagya. Respected dignitaries on the dais,
paper presenters, and all the students. Good afternoon to one and all. It is indeed my privilege and honor to deliver vote of thanks on this special occasion. At the outset, I express our deep sense of gratitude to our chief guest, Professor Dr. Devinder Singh, for his inspiring keynote address. Your words will surely guide our academic community in rethinking policies and research directions, sir, as you have focused on economic reforms through law and sustainable measures. We are equally grateful to our guest of honor for gracing the occasion and enriching it with their valuable thoughts. Our heartfelt thanks to Professor Dr. Thiago Almeida for sharing a global perspective on the intersections of law and economic development and for reminding us that the quest for progress transcends borders. As he has focused on EU policies, BRICS plus G20 and the collaboration that is required on the international basis. A sincere thanks to Professor Dr. Ram Singh, whose address provided deep academic insight into the structural and policy dimensions of India's economic reform and judicial vision that he has focused more upon. We are also thankful to Professor Dr. Kanhaiya Ahuja for his thoughtful remarks and that he has highlighted the relationship between law and economics through various indicators like GDP, gender diversity, etc. Our gratitude also extends to Professor Dr. Avinash Dadhich for his stimulating address, emphasizing the importance of transaction cost and the interdisciplinary aspects of law and economics with other subjects. We are indebted to our Vice Chancellor, sir, for continued encouragement and support that have made this academic endeavor possible. Our sincere thanks to the organizing committee, faculty conveners, and student volunteers for their dedication and planning behind the scenes. A special word of appreciation goes to our distinguished delegates, paper presenters, researchers, and participants who have joined us from diverse institutions to contribute to this dialogue, linking law, economics, and the vision of a developed India by 2047. I also thank all attendees, the colleagues, the faculty members, administrative officers, and the staff, the students for being a part of this session and for lending it the warmth of your participation. As we move forward into the panel discussion and technical session, let us continue the spirit of collaboration, critical inquiry, and innovation that this conference represents to truly realize the synergies between the law and economics for a prosperous, inclusive, and Viksit Bharat. Thank you all once again.
Thank you, madam. I request everyone to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all the participants to please join us for the high tea served outside. We will resume back our sessions within 15 minutes from now. Thank you.
Hello, hello, hello. Hello, hello. Hello.
Members present in the hall, please take your seats.
All members present in the hall, please take your seats. Request people who are outside to come inside and take their seats.
So, whereas fine prints have, there's always trade-off between what we call accented and regular. So, any form that looks simple will necessarily deceptively vague. Because neither side will lay out, so in any contractual situation, especially if you think of infrastructure contracts, this kind of things.
Kindly take your seats. People who are outside, please request them to take their seats.
Storage of data. So it's impossible for either side.
Call the students inside.
Any intent here. Think of all the usages or misuses. Best option is
We are starting. Please take your seats.
something in between and a form. Actually, the best option is that consent is regulated. You don't even have to leave it to individuals. To use. Yes. You can regulate it. Yes. For example, think of sector-wise. I didn't. Sector-wise, you can find out of this.
Good afternoon, everyone present today. On behalf of the National Law Institute University, it gives me immense pleasure to welcome you all to the panel discussion on strengthening legal policies for a resilient economy, being held as part of the International Conference on Synergies of Law and Economics, Pathways to Viksit Bharat 2047. I, Chelsea Mehta, convener of the Center for Tribal Studies and Research, extend a warm welcome to the distinguished dignitaries present on the dais. This panel brings together eminent scholars and practitioners whose insights bridge theory and policy, law and economics, and illuminate how robust legal frameworks can foster inclusion, sustainable, and a resilient economic growth. We are truly honored to have among us an exceptional panel of academicians and practitioners. I would like to extend a warm welcome to our esteemed chair, Dr. M. Prasad Rao. Dr. Rao is a professor in the Department of Economics, Andhra University, Visakhapatnam. He was given Dr. Sarvapalli Radhakrishnan Award for Best Academician for the year 2007. He has also bagged Man of the Decade Award 2019 by Alliance Clubs International, Best Researcher Award by Andhra University in 2006, and is also the recipient of State Best Teacher Award 2014 by the Government of Andhra Pradesh. I would now like to request Dr. Birpal Singh to felicitate Dr. Rao with a planter, a memento, and a sustainable bamboo gift as a token of gratitude. Thank you, sir. Our second chair is Professor Dr. Ram Singh. Dr. Singh is the director of the Delhi School of Economics, University of Delhi. He is a leading scholar whose work in economic theory and public policy has refined how we understand governance and growth. I would now like to request Dr. Birpal Singh to felicitate Dr. Singh with a planter, a memento, and a sustainable bamboo gift as a token of gratitude. Thank you, sir. Now, it gives me great pleasure to introduce the esteemed panelists for the session. I'm delighted to welcome Professor Dr. Avinash Dadhij. Dr. Dadhij is the founding director of the School of Law at Dhirubhai Ambani University, Gandhinagar. He brings with him a wealth of experience in legal academia and institutional leadership. I would now like to request Dr. Seema Srivastav to felicitate Dr. Dadhij with a planter, memento, and a sustainable bamboo gift as a token of gratitude. Thank you, ma'am. Next, we have with us Professor Dr. Yogendra Kumar Srivastav. Dr. Srivastav is a distinguished faculty member from Hidyatullah National Law University, Raipur. His expertise spans law, economics, and governance reforms. I would like to request Dr. Seema Srivastav to felicitate Dr. Srivastav with a planter, a memento, and a bamboo gift as a token of gratitude. Thank you so much, ma'am. Then we have with us Mr. Kushal Kumar Sharma. Mr. Kushal Kumar Sharma is an advocate at the Supreme Court of India who brings valuable practitioner insights into how law and policy intersect in India's economic landscape. I would now like to request Dr. Seema Srivastav to felicitate Mr. Sharma with a planter, a memento, and a sustainable bamboo gift as a token of gratitude. Thank you, ma'am. Now we would like to welcome Dr. Hitesh Thakkar. Dr. Thakkar is an assistant professor of economics at GNLU Gandhinagar. With his deep research in developmental and institutional economics, he offers a unique empirical lens on today's theme. I would now like to request Dr. Seema Srivastav to felicitate Dr. Thakkar with a planter, memento, and a sustainable bamboo gift as a token of gratitude. Thank you so much, ma'am. I'm delighted to inform you that we have with us Dr. Padma Singh as the moderator for today's panel discussion. With over 12 years of teaching experience at leading law institutions, Dr. Singh is known for her interactive and research-driven teaching approach that encourages critical thinking and practical application of legal concepts. I would now like to request Ms. Saubhagya Bhattacharya to felicitate Dr. Singh with a planter, memento, and a sustainable bamboo gift as a token of gratitude. Thank you, ma'am. Each guest is being presented with an eco-friendly bamboo product crafted by local artisans, a small yet meaningful gesture symbolizing sustainability and a collective commitment to an environmentally conscious future. I would like to extend my gratitude to all the faculty members present today, Dr. Birpal Singh, Dr. Padma Singh, Dr. Seema Srivastav, Ms. Saubhagya Bhattacharya, and Mr. Abhishek Negi for making this discussion accessible to us. We have with us Ms. Lavanya as the rapporteur for the panel. To set the tone for the discussion, I invite Dr. Padma Singh, Assistant Professor of Law and convener of this conference, to introduce the theme and contextualize today's session. Please, ma'am.
Thank you so much, Chelsea. Good afternoon, everyone. The dignitaries on the dais and off the dais, all the participants and the students. As we have already witnessed through the inaugural deliberations, the intersection of law and economics provides a powerful lens through which we can reimagine India's development trajectory. The panel discussion today aims to carry that conversation forward to explore how legal structures, economic policies, and institutional mechanisms can together shape the vision of Viksit Bharat. We are truly privileged to have with us a distinguished set of academic leaders, experts, and practitioners who will help us unpack these complex interlinkages. This panel brings together perspective from law, economics, and policy to discuss critical questions like how can economic reforms be legally institutionalized, what kind of regulatory balance can promote innovation without compromising equity, and most importantly, how can our legal economic framework contribute to sustainable and inclusive growth by 2047. With these questions in mind, let us begin the deliberations. The entire session is divided into three parts. The first part, the panels will express their thoughts And then after that, we will have a question answer session. All the participants and the people present in the hall, they are allowed to ask the question or maybe have their specific comments and additions to the discussion. And after that question answer session, we will have the chairs for the session, and they will conclude the sessions and also guide us that what we have got from the panel discussion. So in that particular line, our first panelist is Professor Dr. Avinash Dadich. So we invite you to share your insights. Yes, please.
I think it looks like my day today. Huh? Back to back. I have never had this experience, that back-to-back sessions in an amazing conference. So this time I will talk more specific about from the policy side. I think the topic of this panel is that how law can be more helpful to design more efficient economic policies. So just taking a very practical example. Okay, Jan Dhan Pradhan Mantri Yojana, very simple. The problem was that people don't have bank accounts. Another problem that there is a great leakage in this, money transfer to the poor people. How to solve that? It was very simple, that these are the problems, very grassrooted problems. So let's integrate law, policy, and technology. So the first thing, law. To give them the legal shape and legal background and legal support, they created Aadhaar ecosystem. So this entire Yojana is very much depending on the Aadhaar verification. That if your number, if you are identified in a Aadhaar, then journey starts. And now, as you know, that more or less we are all having Aadhaar card. Even at the very grassroots level, people have Aadhaar card. And having Aadhaar card is not very complicated ecosystem, because fortunately we have very good internet and mobile ecosystem. So we created Aadhaar, that's law. Okay, this document is supported by law. And this document is available to everyone. But that's not sufficient, because earlier also we had documents like ration cards. We had ration cards. But there was a great leakage in the entire distribution welfare ecosystem, because that document, ration card, was not supported by technology. That you cannot verify that whether it's Avinash or someone else, whether that person is live or dead, whether that person is male or female. Okay, so there was a lot of corruption in this entire ecosystem. So the Aadhaar was again supported by the tech people. They said, okay, we can create an ecosystem where each and every Aadhaar card can be verified in a very objective manner. Okay, so this policy was supported by tech and legal people. And the benefit, I just give some data. I think data looks very easy to understand. That from 2014 till 2025, now we have opened more than around like 55 crores bank accounts. That's a big number. And those are all the people who never had any bank account. Second, interestingly, if you talk about from the inclusive side, 56% of those bank holders, account holders, are female. So they never had any bank account in their life. And the first time they got a bank account. And last year only, like 24-25, the government of India and other state governments, they transferred around 7 lakh crore rupees. If you talk about the dollars, it will be like huge billions dollars. But from the Indian side, 7 lakh crore rupees were transferred from state to the needy people. Okay. There might be some cases. I'm not saying that any system is like perfect, but I think this is system near to perfection, where if anything goes wrong, at least we can identify that what is wrong. Okay, because this entire ecosystem is not supported only by law, but it's supported by technology. And now integration of the blockchain technology, and later on we are integrating AI technology in this ecosystem. I believe that this system will become more and more robust in coming years. I think in our country we can find many successful stories like this. I'm just sharing one, but because we don't have time, but if you want, you can read more. We have great stories in our country. And India is the place where we can create something big and simple. The beauty of Indian solutions is simplicity. We create simple ecosystem and we implement them. So when we talk about economic rules or strong policies supported by law, I think they are complementing each other. No economic principle, I think now maybe I will be repeating myself, but again I want to give very strong emphasis that even in our, during the coffee session, we were having this discussion that lawyers and economists, they should argue, they should debate, they should discuss, and we should invite tech people also. So strong economic policies can be only supported by laws when the lawyers do understand the economic implications. I was talking with your Vice Chancellor and we are having very healthy debate and discussion. The idea is that whenever we make a law, we say, okay, let's go for this subsidy or this freebie or whatever, what would be the financial and economic implications for this generation and for the for the future generation? I think this is purely economic analysis. Only economist can, or the financial analyst can tell us what would be the economic implications. We make any law in this country, any law, you take any law and you will find the economic implications, whether it's a consumer law or whether it's a family law, even the family law, criminal law. I'm not talking only about the corporate laws. I'm talking about even very basic, simple laws. The question which I think lawyers we need to understand, I think we are more connected with the policy makers, especially the judiciary, and I think we need to start with the question which I stopped, my last discussion about that. During the creation of that law and policy or regulation, do we have any economic analysis? We don't. Unfortunately, in our country, we don't have that ecosystem where lawyers, economists, financial analysts, tech people, even the policy experts, they sit together and they see a holistic picture. Because in the absence of a holistic picture, see, I don't blame politicians. Politicians are creature only for a few years. Okay, they are bound by their own political considerations. So I don't blame them. I think as a professional people, we need to take this ownership that we need to guide them properly, that what type of policies are required in our country, which are holistic in nature. Okay, not only economically efficient, but socially relevant, future-proof also. Like for example, I give you a very interesting example. Now in France, they are having a lot of strikes, anyway, they like to do strikes, If they don't do strike in 2 to 3 months, they start feeling uncomfortable. So, but right now this is a big strike. And what is a big strike? The government is saying that your retirement age will be increased now from 60 to 62 or 60 to 64. In Indian ecosystem, if we have that type of law, I think all government officials will be very happy. They say, wow, now I will have more money for next 2 years. But it's a reverse in France. They say, no, we don't want to work. Why should I work for extra 2 years? Because my pension is already secured and I don't want to work for another 2 years. The government says, no, you need to work for next 2 years so that we can save some money from your pension account. Because anyhow, when they started their social welfare policies, 8 people were working for 1 pensioner. But now in 24, 25, it's almost 2 people are working for 1 pensioner. Because life expectancy has gone very fast in last 30, 40 years. So the big problem with the French and the European welfare ecosystem is now that how to protect the interest of the pensioners. They have really given their life to this public sector, but at the same time, how to protect the interest of the future generation, because we need capital and resources for the future generation. So there is a trade-off now. And this trade-off, because of the failure of the political solutions, resulted into strikes, demonstrations, and other things. So my suggestion or the discussion in this panel is that whatever we are making, any economic policy or the law, regulation, we need to have a holistic analysis as well as the future-proof analysis, that what would be the implications of this particular action or not action. Okay, error 1 and error 2, what the economy says, when we need to intervene and where we don't need to intervene. Because intervention and non-intervention both bring some economic impact. So I think that type of economic impact for all the policies, regulations, we need to consider very seriously, and not only for today, but for the 10 years, 25 years, because we need to worry about the future generation also. I think with these words, I will stop. Thank you.
Thank you so much, Professor Dadhij. Thank you for your insightful thoughts. Our next speaker is Professor Dr. Yogendra Kumar Srivastav. So we look forward for your reflections.
Good afternoon, one and all present. Respected dais experts present on dais and off the dais, my dear students, participants, research scholars. Basically, since morning I am listening, and I think Avinash sir has used the word soft tension in the hall itself. So I will not create that kind of atmosphere. So I'm taking help, or whatever the important observations made, I don't try to repeat and focus on that. Always my intention is to talk something which is not discussed. I'm trying my level best as a learner. Always we as a learner, we are trying to learn every time something, even through this important panel discussion. We will think which is not within the purview of law, within not the purview of economy, and what exactly we are talking about within the permissible limit of policies as well. Then the question comes to our mind, and what we are going to discuss. Yes, there is something concrete, we have a concrete or good models which are exist in the society itself since long. When even much before we are talking about freebies, much before we are talking about this Jan Dhan Yojana, much before this Ayushman card, then what kind of developments we are seeing or models we are seeing? Because I am coming from Hidayatullah National Law University, Chhattisgarh, we are celebrating 25th year celebration is going on today. Prime Minister Modi is there. One important first program he is going to attend. Are we aware? He is going to interact with the more than 3,000 children recently undergone with the heart surgery free of cost conducted by one hospital. This is a model much before Ayushman Yojana. Even sometime you will see not it is covered because it's a very costly affair. If you will approach to any AIIMS, we will never get an opportunity or an appointment. Even today, this is a hardcore reality. If you will approach to any government medical college, and it is directly affecting to whom? Downtrodden people of the society, marginalized class of the society. They are not able to even approach this class, Apollo and this kind of a 5-star hotels, or we are sometimes using hospitality is not possible for us to. He is going to interact with this in Chhattisgarh. This is not only one model, it is across country this kind of free services some institutions they are providing, which is cost effective or it is free of cost. This is a kind of a model we have to adopt, and the people they have a money. Ultimately it is with few people or we are sometime we are talking about 85% resources is limited to within few industries or people they belongs to Adani, Ambani's or otherwise, few more people. There is a model within that group. Long back it is created by Tatas. They established quality hospitals. It is again is a good model, and it is basically is a very good cancer hospital they have developed in Mumbai. This is only one example I am taking. There is another good industrial house, Birla. Birlas, they developed, constructed many temples as well as hospitals. There is no law at that point of time if you are connecting it with the CSR activities. No, not at all. It was the Section 135 of Companies Act 2013, read with 7th schedule, was very much available at that point of time. Now under compulsion, what these houses are doing, they developed, established their own foundations. And because I'm closely observing all these foundations, and because my younger brother was a part of at least 3 top-level foundations of the country, belongs to different business houses, I know the model, what kind of a model they have adopted. And we have to check this when we are talking about this kind of economy. And also simultaneously, sometime, just time is limited, I will talk about, if we are talking about law, then definitely I will talk about a specific law, Competition Act, 2002. We are talking about some companies are using abuse of dominance. Then my question is this: government is misusing, abusing this clause first, because they have a kind of a cartel in a specific areas. They are not allowing to enter anyone even today. Even today, there is a still, you will see there is an existence of, for example, it is a petroleum sector. And during elections, suddenly you will see the sea change. They are decreasing the prices of gas. They are decreasing the prices of petrol. They are decreasing the prices of this and that. Means they are controlling. This kind of control they have. And it is affecting to whom? It is directly affecting to us, common people of this country. And basically they are making a cartel. There is a cartel. And they are operating this cartel. Government is misusing this. And even they are not falling in this in the category to handle this kind of activities under the Competition Act. And competition, CCI is still, I filed an application before the Competition Commission of India for this very purpose. They categorically denied to entertain that with this beyond their jurisdiction. Maybe this is. And if you will see, there is one important point which is also related to, we need smart regulations for future technologies. This is with reference to AI. This is with reference to blockchain. This is with reference to gig economy. I want to just point out one very important thing. Where there is no law, we want to make a law. There is no regulation, we want to regulate. Is it required every time to regulate? What happened? Today morning someone, Deven sir was mentioning that farmers' agitation is required to pass such kind of regulations. कोई भी एरिया छूट गया हो, सरकार चाहती है उसको दबोच लो, एक रेगुलेशन और एक रेगुलेटर बना दो, उसको रेगुलेट कर लो. And we are talking about open economy, free trade. But simultaneously we want to regulate everything. And the enormous powers in every specific legislation you will see, the exemption power is given to the central government specifically. Specifically, whatever they want, they will give a kind of exemption to any specific industry. They will give such kind of exemptions to everyone. And this gig economy they are going to, and they already is involved in that to regulate with the and this is basically is a very gray area, they need basically a kind of a support from the side of the state governments, sometime umbrella of social security covers. For example, in case of any accident, when they are approaching to deliver any parcel, if there is an accident, a lump sum amount should be immediately, we have to disburse to that family. Instead of that, we will impose companies to intervene in that, and they will treat that person as an employee. Then there is a employer-employee relationship will be come into picture. Then there is a role of a labor code 2020 will come into picture. Then they will fall under the category of this gig workers definition of this. Because what we want to regulate. They should treat them as a, maybe you will be not with me or you have a difference of opinion of this. And ultimately, we have to leave some sectors to grow themselves, specifically. And sometime, no regulations, no law, no specific regulators are required. Where we have regulators, for example, at the time of mergers, acquisition, amalgamation, we need a consent, prior consent is a prerequisite to go ahead. Are they really giving a honestly they are giving a consent, or there is something is going on? NCLT is not happy with the, NCLT is not happy with the lower NCLT judgments. Sometimes high courts are not happy with the NCLT judgments. Supreme Court is not happy with the High Court's judgment, and they are the fellow brothers, colleagues in their passing instructions. So, in my opinion, whenever we are talking about synergies of law and economics, it should be to the some extent we should provide a free space to move ahead. This is ultimately I want to sum up in conclude. I want to conclude. Everywhere we are full with laws, then rules, because DPDP Act 2023 is there. We are waiting when the government is going to come with the regulations. DPDP rules sooner or later will be notified by the central government. And it is, then there is another area. But now it is individual specific, and we are thinking this IT Act is irrelevant with reference to this data protection. This is not a time to discuss is it relevant or not IT Act to handle this kind of situations. If otherwise you will go through with the IT rules 2009, 2011 and 2021 rules, then it is more than sufficient to address much before EU GDPR. We passed this kind of a very good legislation to handle this area. But we want to regulate. Yes, regulations are required to just deal very important areas, but there should be some specific areas. We will leave that space to open for discussion, and society should develop a different kind of models. Particularly, one or two models I have just mentioned before you. Many such models in different areas are available without any law, without any policy, without any support, government support. They are growing fast, and they are giving a kind of impression we can grow together, we can learn together through this kind of a model. Thank you very much for providing me this opportunity.
Thank you, Professor Srivastav, and thank you for highlighting the good models and how it can play a very good role in the economic regulation that you were focusing on. So thank you very much, sir. We now have with us Dr. Hitesh Thakkar. Sir, we invite you to share your perspective.
Good afternoon. Respected dignitaries on the dais, and my dear fellow paper presenters and all invited guests. Firstly, it's honor to speak in front of somebody who is really we consider as a, in Indian context, a different kind of law and economic aspect. Sometimes we say he should be considered as a institutional builder of law and economics. So in front of Ram Singh sir and even Professor Anita Nagar, I think it's quite scary, and it becomes very difficult whether I will make some meaningful communication from my side. Yeah, let's start with, there are many discussions are going with regard to economics and with regard to law. So separately, if we take law and economics, both are in the one understanding, that is a common science, a common understanding, a common sense. So I think both subjects do work on the common sense. Mostly, when you look economics, then we try to look something from the efficiency point of view, but not without breaching the rules of game. And when we talk about law, we look law from the justice and fairness and equity point of view, even not without breaking rules of game. Like people here talk about that the system with regard to the negotiable instrument, get required trials and all that process. That's fine, but justice should be delivered on time rather than, so that means economics is discussing something on timely delivery, something, and from the law point of view, it should be just fair. Moreover, when we look from the law and economics, I think, yeah, it's quite tricky. Like sometimes we have to do trade-off versus efficiency versus equity. So the very important judgment we comes in our mind is about the firecracker judgment in Delhi, where Delhi court, you know that Supreme Court told that there will be no firecracker in the festival season. And yeah, so that was quite right, from the right to health, right to clean air. I see some of the people do face respiratory problem, I think in that regard, and even the normal people we see here, I tell many of us have respiratory problem. If you don't want to confirm, you can go and check your lungs. I think you will get it. So it was quite relevant judgment, but whether that judgment was enforced or not, that was the question. Because still people have firecrackers and all that stuff, and how far you can enforce it, that was in the question. And recently, yeah, the recent judgment on same firecracker in the festival, that green firecracker, I understand green firecracker, but how far you will enforce green versus non-green? Yeah, what is green? It's firecracker is firecracker. Even it is, if you scientifically do study, I think you will find there are some problems, but the problems are comparatively less. But how you will enforce, that is the question. So yeah, but in one of our, we consider our Justice Sikri from the point of view of giving his judgment from the law and economics point of view. He mentioned that there is no trade-off versus efficiency and equity, and he told that both can go hand in hand. I feel that that's what is the time of requirement. And Indian law and economics, I'm greatly thankful to the Ram Singh sir and my colleague and my guru Naita ma'am, with regard that doing something on Indian law and economics, and where they do take care of no trade-off, we can take both the things without not compromising that. If you're doing that, then I think you are come out with the full discussion from the law and economics point of view. Though I have done research mostly on two law. One is insolvency and bankruptcy law, and other is disability law. I think people will say one side you are talking corporate law, other side you are talking human right. But I think both are quietly interrelated. So when we talk about insolvency and bankruptcy law, we talk about only two important stakeholders. One is creditor. Generally, creditor has given loans, has provided goods and services to debtor. And generally what happens, game is simple, everybody pay timely intervally payment of goods and services. Yeah, if loan has given, they pay timely intervally principal plus interest. And that is what going. And some of the cases do happen that payments are not paid, either of goods and services, either of not paying principal and interest. That means loan has been given, he got defaulted. And generally in economics, we give them as a name as NPA, bad loan, distress asset and thing. And we have a recovery system. I'm talking personally not about the individual default or personal default, I'm talking about the insolvency and bankruptcy. So code was established in 2016, and it was one of the leading codes, and it was based on the principle of economics. Now, first principle, it says that the cases has to be admitted in 14 days. And that was the showing the timeline, how far the code is so time driven. Moreover, also code says that it has to be completed in a time driven. So time driven was given 180 days. Any case coming to the IBC, NCLT, it has to be admitted in 18 days. After admission, it has to be completed in 180 days. Max to max one-time extension, that is 270 days. And you know, Supreme Court judgment in India, it's a precedent. So one of the Supreme Court judgments says that in any matter, thing has to be completed in 330 days. So we have a 3 deadline, 180, 270, 330, and first deadline 18 days. And yeah, and the good thing about the law in economics that it doesn't, people don't talk about the specific law, but they try to go in field. So I got opportunity to go to the NCLT Ahmedabad. I was a really intern then from morning 9 till 9. So I was attending both the batch. Morning batch I was attending from 10 to 1. Evening batch I was attending from 2 to 5. Someday I was so fortunate that even NCLT Ahmedabad do take matter of NCLT Indore, do take matter of NCLT Chennai. So I have attended that also online virtual proceeding. Now, fairly none of the matter till now has been admitted in 18 days because Supreme Court has intervened and has said that it is not mandatory. Now, I don't know how far you are making the law and you are not going the true spirit of intent of legislation. Moreover, none of the cases are being completed in the timeline. My research shows from the 2016 to 2022, on an average, it takes 430 days. So I was saying 430 days for completing one case. So I was quite liberal. When I have seen the IBBI website, it was 540 days. So still I was quite 100 days less than what the IBBI website, the IBBI data was saying. One of the cases, the maximum time taken in one case was 1540 days. Means maximum time taken was 4 years and 2 months. My research was of the insolvency has come and it is completed the 5 years. So maximum was 4 years and 2 months. And I was presenting in front of somebody who was saying, your research is wrong. You don't know that maximum time taken was 8 years. I'm presenting in 2022, but by data in 2025. So I agree with what you are saying is correct. So times are taken even significantly. So that is okay, understandable. There is one interesting clause. And I also look the law, then I find that in the IBC, we give status of COC to only financial creditors. And when you become financial creditors, that means who have given loans to the debtor, they get the status of the financial creditors. And when you get the status of financial creditor, you are the part of COC. When you are part of COC, you have the voting right. I was doing study and I found that majority of cases are going in liquidation but not in resolution. And I was also in thought that why this voting threshold is 75%. By the way, I don't know, through ordinance, the new rules was passed and they have reduced to 66%. And majority of cases which were going into liquidation was later stage gone to the resolution. And that was quite thoughtable with the amendment of that law. But there are some instances, I will take 2-3 minutes and I will complete my presentation. There is one clarity with regard to the code that financial creditors are part of COC and they can take and make decision from 66% voting right. So now generally what happened when they are coming out with the resolution plan that favors to only financial creditor, they are excluding to the operational creditors. And yeah, they can do that. So I was attending majority, I said, I am telling from the court proceeding, I was sitting there and there was judgment was against with this. So court says that, so there was a lawyer, he argued that according to the SR judgment, when you come out with the resolution plan, it should be based on interest of all creditor, interest of all creditor. But you come out with the resolution plan which is only biased to the financial creditor. So it was put a stay and asked that you have to come out with the new resolution plan where you take interest of all creditors. So yeah, I was I told to some of my students, and my students has recently gone to the observation to the court NCLT, and they found that, sir, what you are telling, still it is the matters regularly, weekly 3-4 matters come with regard to their resolution plan, which is prepared by the COC, which is only biased toward the financial creditor. Though the things are settled, but things still are coming in such a way that they come out in a way that only they take an interest of that. So yeah, I think the interaction of law and economics is not only about the economics, but I think about the law also. And I think something what I have learned from my own journey, I think I will be always thankful to the law fraternity, because something has to be knowing from them. And as an external, as a third person, I was not knowing IBC, just I was listening the cases, and then I come to know many things. So I think it become an independent observation done by some independent scientific investigator. And I think, I personally feel all subject can be interdisciplinary with law. So what law and economics is doing, I think they provide the scientific way of looking the things, and they provide the scientific reasoning, and some of the issues which they are giving the solution, I think it's quite workable to implement and enforce. I have many things to discuss, but I think I will restrict myself here because I'm interested to try to learn from my colleague from Kusal. Thank you very much. Thank you.
Thank you so much, Hiteshi, as you have shared your insight with respect to IBC. And when you are saying that financial creditors are given no more preference, then I would like to add that even financial creditors, due to no lot of haircuts under the IBC system, only the secure creditors, even they are also not finding anything from the this system specifically. So yes, it requires a lot of changes. Thank you once again. Our final panelist is Mr. Kushal Kumar Sharma. So we are eager to hear your practical insights.
So good afternoon to all the dignitaries and participants and all the august participants, everyone present here. So I am Kushal Kumar, and I am a founder of a law firm, and I feel after so much of discussion, I am one of the main contesting party here, because I am a practicing lawyer. And there has been from the start, what I am hearing is there has been a lot of criticism against the judiciary, the path of justice being too tough, and the roadmap of securing the justice is too tough. So let me be clear that being as a lawyer, being as a practicing lawyer, someone who is really worried about the marginalized people of the society, who really want to give justice to the society, and someone who really want to take your infringement of fundamental rights to court and to make you deliver justice. So I am, being as a lawyer and being as a legal authority and law officer of the court, I am someone who will take you to a journey where the judiciary and the role of lawyers in it, how are we giving an economic immunity, not an economic resilience when it comes to the part of law and economics. So let's talk about how we started it. See, I will take you to a very brief analysis of what I have researched in the way of economic resilience when we started it from the pre-independence to post-independence, and when we started the all grounds of economic nationalism. And in 1905, when we started the Swadeshi boycott movement, by that time was the first time when the economic resilience came to our country. And when we really started to think about our economy. And that is the reason the fight has taken such control that in 1947 we got the independence, and then after a new economic strength and the new economic growth came to this country. So see how we defined our path as economic resilient country. So from 1947 to 1991, I took this as early independence era, where it was a planned resilience. So a planned resilience came in as 5-year plan to green revolution to a very mixed economy where we were trying to sustain, where the general crowd and the general public was trying to sustain, and we were a developing country, and we were someone who really wanted to grow and who really wanted to match the international and the national interest. So after when 1991, when the liberalization, privatization, globalization came in, so post 1991 to 2014, I defined this era as a adaptive resilience. And in this adaptive resilience era, it was a economic reform, it was a service IT boom, and it was a global interaction and the global interrogation where we came as a part of global structure. And then after from 2014, this economic resilience came as a structural resilience where it came as Atmanirbhar Bharat, where it came as the Make in India, and where it came as a digital revolution, where we are doing a lot of UPIs because here in the morning, a lot of people were talking about the digital revolution, how it came in. And then after it came as the DPDP Act, which is coming in. And then it came as now the booming industry is the startup ecosystem. So that's how I defined the whole economic era of this country. So being as someone who is very much involved to the day-to-day affairs of the society as a law officer of the court, I feel that judiciary has always given a major role in defining the legal structure and the legal what do you say, as a legal regulatory and a legal, a economic legal structure to the so much populous country where each and every person has their own way of living and how they want their household to run. In the morning when I was hearing one of the dignitaries, they told that the government is now trying to enter the household of the each and every individual, and the ecosystem is becoming like the government is trying to regulate each and every sector. But there is one more question which is coming up, that on what way the economic growth we want in this country, like in lieu of what cost? Because if we don't regulate the unregulated part of this country, such as the OTT platforms, if you see, and such as you see the gaming industry, yes, I am in the favor that one night there was a law passed and our multi-billionaire industry was closed down. But we have to see on what cost it was closed down. The point here is that due to this addiction, the generation was getting ruined up. And because it was unregulated, we never focused on that area. And once the regulation came in, it was like we have to close down this because it is not good for the coming future generation. So now, see, I will tell you, because I work in the sector of banking and finance, I work in the sector of petroleum also. So when you will look to the how the judiciary and the lawyers are contributing, when you will see the commercial court litigations, when you will see the NCLT, when you will see NCLAT, when you will see how the Supreme Court and other courts are working, see, I will tell you the structure. When you come to the commercial litigation, if you want an economic resilience, then you have to see all sectors of society. You don't have to see only the upper sector of the society who can afford a good lawyer and come to court. If a company, if a startup, if even a small 4-people company want to wind up their company, there is a particular law to regulate. And now, because we want to lower down the burden of the judiciary, because there are lakhs and lakhs of cases pending, so we introduced 12A section, which is very important, which says that there is a pre-lit mediation before filing a case in a commercial court or a commercial dispute court. So that's how the judiciary is helping us. If we come to NCLT, the Hitesh sir just talked about the laws, the insolvency law, and the and for me, I'm as I am looking for petroleum and natural gas regulatory board also. Sir Yogendra sir talked about the petroleum sector. So I will tell you that when in the morning there was a discussion about the expert panel. So every regulatory authority, if there is a tribunal and if every regulatory authority court is running, then there is one technical member who is the expert of that regulatory authority and who is also sitting as a judge. So even we are calling that technical member as my lord every time. So now see, my prerogative here is to discuss how we as lawyers and how judiciary is as one of the major part of this regulatory economic resilience ecosystem is helping even each and every, even the smallest and the tiniest part of the society, even the tiniest individual who really want to come to the court. Because now approaching courts are so easy, that is the reason the pendency is so high, because judges are less and people are and because of the economic growth, because of the structural economic growth what has come to this country, that is the reason everybody is ready to fight the litigation. People are coming to the courts, and because they are coming to the courts, so they are feeling secure that yes, if I am coming to the court, then they will safeguard my economic right. So if we talk about property cases, if we talk about digital cases, digital economic cases, if we talk about cyber crime cases, or if we talk about our Company Act cases, everything, the epitome of each and every securement of right is judiciary. See, criticism is a very easy part. We have to understand that how the smallest part of the society will be secured. The securement of each and every tiniest to the tiniest part will come when the ecosystem will be strong from the roots. And the ecosystem will be strong from the roots when each and every people will believe that yes, justice will be delivered to me. See, if I say that there is a long delay in delivering the justice, but I really believe that justice is not a form of revenge, because revenge comes very instantly, but if you want justice, it takes time. Because you have to prove your point, the burden is on you, you have to prove your point, and that comes very systematically. So how I took this when this topic came to me, I have always focused on how the lawyers and how the judiciary and how the law reforms is helping the litigators and the people who are coming to the court, and how they are safeguarding their rights. See, we introduced judicial activism. When there was no law for anti-ragging, we introduced anti-ragging laws. When there was no law for domestic violences, we introduced the domestic violence laws. When there was no guideline for safeguarding the women on the workplace, we introduced Vishakha guidelines. So what is this? This is a part of the economic growth only. So if we talk about that woman is also a main part of this economy, then we are safeguarding that economy by bringing the laws which are hollow at the point of time when nobody is looking at it. Even the government, even the biggest to the biggest individuals are not looking at it. So I'll rest my case here. There is a lot to say, because as a legal practitioner, I know how we are working. And thank you so much for getting me this opportunity.
Thank you so much, Mr. Kushal, for highlighting the role of judiciary in economic justice, and also highlighting the reasons behind all the new laws that you have specified. Now, the rest of the part of this panel discussion is, the first part we are going to take some of the questions or comments from the audience today. And for 5 minutes, we will open the floor. And after that, we will have a concluding remark from both the chairs for this session. And they will be allotted 5 minutes time each. So now the floor is open for question or comments or any specific addition if you want to. Hand mic, please. Please provide hand mic to sir.
Yeah, I don't have a specific question, but I just want to probably agree with what Advocate Kushal had to say, and I completely echo your concern because I think we are somewhere missing the point of subaltern population, and we are also somewhere missing the link of subaltern population in this whole dynamics of how law and economics are related. I mean, there is a very wonderful book of Rohit Dey's People's Constitution, and if you really look into that book, it goes into several cases of butchers, prostitutes, sex workers, bar dancers who are actually confronting with the government with the issue of regulation. And there is this entire idea of economic justice involved because at one point of time, people are saying that, okay, working is an immoral idea. Prostitution is an immoral idea, but what about their right to work? Similarly, a butcher, if you talk about banning of cow slaughter, but what about slaughterhouses? So who is talking about those, I would say, as I said, subaltern communities is really where the Supreme Court or the judiciary has come up in bridging the gap between economic justice. So I think these are also those case studies as models that we should be observing while studying the synergy between how law is impacting the economic resilience. So I totally echo with Kushal's concern. Thank you.
Okay, thank you so much, sir. Anybody else? Any question from the house?
Sir, my question majorly revolves around a gray area currently, which is the online gaming bill. So, and my question is for two of the panelists, Yogen sir and Kushal sir. So, there is like a conflict of opinion that I had seen. Yogen sir is more in favor of deregulation, from what I gathered from his speech here, that due to the issues of having cartels and favorism from government in the form of regulations, there is a discrepancy and there is a we can say that unfair usage of discretions. On the other hand, Kushal sir has provided a sort of a flowchart. We can say that there is a need of securement among the society for which there is an ecosystem, and that ecosystem is created by the belief of people, and people derive this belief from regulatory bodies and regulatory statements or drafts. So the current online gaming bill, it is a matter of conflict, reason being that there is no particularly clear stance on the RMG bodies, which basically have been regulated or being restricted by the bill. So I want to know the opinions of both the panelists. As Yogen sir had pointed out that these regulations often restrict the scope of the futuristic developments, and Kushal sir that these regulations often provide security to people. Because online gaming bill raised a lot of questions that what about those games which basically focus on the debate of skill versus luck and other things. So please sir.
It's a very deep question and a very practical question. My answer will also be very practical. Right. See, when you talk about the online gaming so you have to see what the courts have done in this particular sector. So there was one case in Delhi High Court, NFT case, but NFT case, non-American case. I was representing one of the parties in that case. Right. So that was the only one case in India by that time, and now the online bill this came out. So that case was of personality rights issue. Personality rights issue is a very important part when it comes to online gaming app, because they use the personality rights of the cricketers or the celebrities without without asking them, right? So they came to the court seeking about the concept of NFT because NFT was never introduced in India, and they came to the court seeking about their personality rights. These days, the personality right cases are, a lot of cases are filed in Delhi High Court, and one case was also filed in Madras High Court. So my prerogative to this question is very simple. It is simple when, see, maybe a lot of people are getting employed by that gaming industry and all, but we have to see the gray area of that side. The gray area of this complete structure is that lot of people are losing their hard-earned money, and lot of homes are getting destructed. And because it is unregularized sector, so that is the reason nobody is touching this sector, and it was the need of the hour to get it to introduce the bill. And in few years or in few months, we are going to see one regulated bill for this sector also. So that is my point. See, my point totally revolves around the individual rights, personality rights, non-fragile tokens and all, and how one and all can come to the court and protect their the fundamental rights which are getting abused.
Just with the help of two examples. Earlier, Maharashtra government banned bar dances. What happened? Recent Supreme Court judgment is there. Second, RBI deregularized, prohibited sale and purchase of Bitcoin. What happened? They launched themselves the digital currency. Third point, which you are raising right now, we all are using in this hall smartphones. Anyone is restricting what we are seeing can restrict us? No, just a minute. Just a minute. I am just talking about that. And the consent matter is going on, day-to-day hearing is going on to reduce the age of consent to sex from 18 to 16 years. 16 years. And there, the opinion of government is different. You will see the outcome. I am not mentioning what outcome will be because the Justice D.Y. Chanchud already given his opinion, not the judgment itself. Where we are, we want to, this is my autonomy. This is the autonomy which is available to me to use my body as well as my control over my soul. And as a prudent mind, what I am going to see and what I am going not to see, you cannot decide as a government. And basically this is a rightist approach we have, which we want to impose on a common man. This is basically a matter of a dispute, and you will see the outcome of this judgment because the constitutional validity will be challenged. And I am not saying what should be the outcome, and later on you will see that because it is a very important area. The earlier speaker and he talked about this. How many stakeholders are involved in one decision? Because yesterday I was a part of one consultation conducted by Ministry of Law and Justice and my Honorable Vice Chancellor, because it is only exclusively for the law schools, law universities Vice Chancellor. My Vice Chancellor nominated me. And there was one question raised by one existing Vice Chancellor of a prestigious national law university. The government is making laws without consultation. And I don't want to quote the law minister. N number of judgments. It is a post 2013. What is the specific observation with data mentioned by Honorable Supreme Court in the leading judgments about misuse? I'm not talking about that. And one important criminal law example is with us, 2013. After J.S. Verma committee report, there was an amendment in the law. This is my observation.
Thank you so much, sir. You have a question? Last question for the day? Yes, please.
So sir, I have a question on the banking industry. The banking industry has a lot of norms which are not known by a lot of people. Like, what are the parameters that they use? And I think for a business, access to money is one of the most important part. So how we can open that opaqueness and maybe deregulate it via use of data? How can we actually design the parameters all in open, and what kind of policy work that can go there in order to let everyone know as to what are the rules of the game so everyone can play? Because today there is a lot of opaqueness in this system, and I think that is somehow harming a lot of new people in entering into the business. Thank you.
So, see, the point here is that I am fine if a lot of competition is coming in. What is wrong with that? If lot of NBFCs are coming in, if lot of banks are coming in, and if the normal citizen of this country has a lot of options to choose, then what is wrong with that? Firstly. Secondly, there are a lot of laws. Citizens also to get what is the most efficient side of the part what they are securing, and what they are asking from the concerned sector. So you have to read the documents, and once you are reading the document, every bank has their own agreements. So you read that accordingly, and then you move. Although all the sectors are at this point of time, all the sectors are regularized and are working properly, as per what I have seen.
Thank you so much for this reflection. I now request our session chair, both the session chairs, to kindly offer their concluding remarks and reflections on today's panel.
Distinguished dignitaries on the dais, particularly our respected Professor Sur Prakash Garu, Vice Chancellor, National Law Institute University, and other dignitaries, and Dr. Padma Singh Ji, Professor Avinash Ji, Professor Ram Singh Ji, Professor Yogendra Kumar Singh Ji, Dr. Hitesh Thakur Ji, and Mr. Kushal Kumar Ji, and also Birbal Singh, Professor, Chairperson, Center for Tribal Studies and Research, and Dr. Seema Srivasu, Chairperson, Center for Law Economics and Convener, and other coordinators, organizers, distinguished participants, faculty, scholars, students, ladies and gentlemen. I don't want to take much of your time, and it is indeed an honor and a proud privilege to participate in this international seminar, conference on synergies of law and economics, paths to Viksit Bharat 2047. I'm grateful to the Center for Law and Economics and Center for Tribal Studies and Research, and also National Law Institute University. And particularly, I'm very happy to participate in this panel discussion on strengthening legal policies and resilient economy. Since morning, we have been listening many speakers, too much of information. So one important observation is, normally in these seminars, in these conferences, what we do, so we accumulate traditional knowledge. The most important thing in this national, international conference, that is we are on the particularly we are on the horizon of new knowledge. So that is the most important thing I observed. And also talking about synergies of economics and law. And so that relationship, that link, unfortunately, it is weak at the moment. What I observed by listening all the speakers. So we are supposed to strengthen the relationship between economics and law. That is one important thing. The most important thing is everybody is talking about development. Development is nothing but it's a good change. It's an enlargement of people's choices and capabilities. And those capabilities are missing in this end. Are there any rules? Are there any regulations? Are there any laws regarding these capabilities in this country? That is one important. Because these capabilities are associated with the consumption. The welfare is linked with the consumption of the goods and services. That is not there. That's why we are struggling. The most important for any kind of society, for any kind of government, two important aspects. How to generate adequate employment and how to generate small incomes to the people. They don't want lacquer overnight. They don't want to be millionaire overnight. That's a greedy people are there. That's a different thing. But we are talking about, many people talked about common man. That is the most important thing. And particularly, the economic strength we are talking about. So, the economic strength is particularly the aspirations, the recent aspirations for the next quarter, and economic transformation achieving $30 trillion. Ours is $4 trillion and $5 trillion. And we are talking about suddenly, overnight we heard this $30 trillion in a quarter time, and also $18,000 to $20,000, and also social empowerment and environmental sustainability, and also transforming into a prosperous, inclusive. And where is the distribution inclusion? The distribution part is missing. And sustainable nation by 2047 require collaborative efforts. That is why this international conference is very important. So, talking about the concept of Viksit Bharat and developed India. So, who is going to be number one in the world? So, India is going to be number one in the world. So, we are talking about policies. So many things talked about, all the panelists. Is freebies, they're talking about education policies, and so the most important aspect in recent Human Development Index. Yeah, I mean in the recent Human Development Report, so 1% of the people controlling 40% of the wealth. Is it legally valid? Is it legally justifiable? And why the policies are not thinking about these things? On one hand, we are, looking at the situation this. On the other hand, look at the situation, people. So millions are below the poverty line. So somewhere it ends multi-dimensional people talking about somewhere ends at multi-dimensional poverty. So is it possible in the face of earth? It's a doubt. So these things are there, and particularly these aspects we are supposed to cover. One important aspect is also there. We are talking about demographic dividend. And in this country, there are 550 million people between the age group 18 to 25. And we are not able to convert them into human resources. So is it not a legal problem? And can't we provide solutions to such kind of problems? So how long we will take? So poor people cannot wait, and these things are there. That's why the policies we have taken so far are very, very limited. These policies are not sufficient to tackle the prevailing conditions in this society, one thing. And what are the policies we have taken? They are not implemented properly in this country. Say, wherever people's oppression, people's involvement is there, so some kind of justice has been done. But in all sense, it is not there. That is another important thing. Another important aspect, when I was studying with Professor Michael Lipton, say long back, has written wonderful piece of work, Why Poor People Stay Poor. So in that book, so urban bias, the differences in this world, not between the rich countries and rich countries, not the rich countries and poor countries, and not between the East and West, not between the capitalist and the socialist, not between the, say, rich people and the poor people, but the differences within the countries, that is the rural-urban division. That is the most important thing. Are we taking any care of these policies, law, and regulations with these differences we are supposed to think? And in the coming years, millions of people are joining in the urban areas. And what is going to happen in the urban areas after 15 years? Or at least look at after quarter century. And say, are we planning anything? Are we, with regard to the developments, are we taking any policies? And these things are alarming in my mind. That's why I thank the organizers for having given me this wonderful opportunity. This is a beautifully organized international conference, and so many things, so many problems, issues plagued in the country. So certainly this university and this conference trying to show some solutions. Thank you very much for giving me this wonderful opportunity.
Thank you so much, sir. I would now request Dr. Ram Singh to lend us the lens of his perspective and conclude the session.
Thank you, Shally. I know that I'm literally standing between you and your meal, your first meal of the meaningful meal of the conference. So I will wind up in two, three minutes. I have heard the panelists today with great interest and also questions. I want to talk about 2-3 themes that underpin, in my view, the entire discussion. The discussion has covered broad spectrum of issues related to downtrodden's, their rights to economic efficiency, and also interest of corporates through NCLT. To me, one theme that runs all these issues is the issue of information. The information we give, we provide, or legal systems provide to citizens. A significant part of litigation is driven by asymmetric information, different beliefs of litigants. The other substantial part is driven by strategic. Strategy could be to extract money, to harass, or these are two leading, be it property, contract, be it criminal law, is whether they are increasing, they are spreading more, they are conducive for informing citizens or not. So that's one good yardstick. The related issue is that when you and I, if we think of whether property-related disputes or contractual disputes, some of the disputes originate in the first place because we end up signing contract with the wrong party. We expect something from product supplier. Product suppliers, the warranty we get is also an implied contract. So we expect something by way of service or product that the supplier didn't intend to provide. So there could be an element of a fraud, or a fraud that will not qualify as a fraud, but essentially hiding information. And so this type of transactions that happens under asymmetric information are not necessarily good for society. We call them, they are not Pareto improving transactions. They lead to litigation. A similar idea plays out in the context of property-related disputes. So especially in our country, when you buy a plot, you buy a flat, you can't be sure, 100% sure that you are dealing with a real owner. Or even if you're sure of the ownership, you can't be sure that the plot or the apartment will be delivered on time. It has both property ownership element and also contractual element. But again, the issue is of informational asymmetry. So one yardstick to study and examine legal systems is on the information angle. To the extent legal systems are designed or modified to spread information, they will enhance social welfare. They will also deliver more justice. So this issue. So Aadhaar, Professor Avinash mentioned about Aadhaar. One role of Aadhaar has been to reduce informational asymmetry. Once you know my Aadhaar, professor, non-professor, you know my Aadhaar, you know who you are dealing with. If we can link our property also with Aadhaar, then you would also know who to catch if it turns out that there are multiple. So some of public policy interventions have been, to the extent they have reduced informational asymmetry, they have reduced litigation, they have improved transactions, economic efficiency, economic welfare. Some of crimes have disappeared. The crimes, people could run away with your mobile phone. They could commit crimes, heinous crimes in vehicles. Some of those crimes have been reduced again because of Aadhaar. Aadhaar have been linked with mobile. As a result, some categories of crimes have come down significantly. That is the role of some kind of intervention and basically giving more information to citizens and also law enforcement agencies, how to catch. If I committed a crime with my mobile, you could trace me. The other new issues, however, have appeared in the form of cyber crimes. Deep fake crimes that were deep fake, mimicking personality of someone. I am not worried about, if Akshay Kumar's or some celebrities' personalities get mimicked by deep fake for commercial exploitation. Problem arises when those deep fake personalities are used to spread misinformation, to sell products that actually are fraudulent products. So again, the issue is essentially going to be of information, informing citizens and also law enforcement agencies. And there we surely have to take help of experts and also technocrats in the process. The other point I want to make that issue came up is of incentives we generate. When we grant rights, we generate incentives in the process, whether we look at women's safety at workplace or any other legislature that has come in, or we look at that stringency of criminal law in the aftermath of Visakha judgment. So we have tried to give some rights that are backed by fundamental rights to some categories of citizens. In the process, however, we have generated some incentives. The legal change that gives more right to a woman to workplace safety, if it is not applied under symmetric information system, it also generates incentives for some women to misuse that right. Okay? So therefore, we have to be mindful if we want to guarantee that every woman feels secure. It's a paramount. We also have to be mindful that some others could misuse it. Our analysis, economic analysis will come in assessing the magnitude of frequency of these issues and also making interventions so that we protect rights while minimizing errors of other types. In a similar vein, I think it was Professor Srivastava who mentioned that now heinous crime of rape is followed by heinous crime of murder. I had pointed it out early on. In some matters, we have to look at things, with calm brains. There's something called, marginal deterrence. If you have same punishment for 2 different degrees of crimes, the criminal, you see, so can I just take 1 more minute, sir? You would notice that, many crimes are committed by, people say that they are criminal, they are crimes of passion, There are also drug-induced crimes, or also there is a genetic proclivity. However, you will notice that, even crazy-looking people do not mug you, do not commit crime against any woman in broad daylight, in a well-attended, well-lit road. They also choose their spots to choose their victims. The point I'm making is that there is an element of rationality, calculation, premeditation. Mens rea is at work to different degrees. This means that we have to keep in mind that when we design, when rape and rape plus murder, if they invite same punishment, then even crazy people would want to eliminate evidence against their criminal act by killing the victim. So we have to, when we go for law and economics analysis, we have to be mindful of even, rape is among most heinous of crimes. But we also have to keep in mind incentives it generates. And this is the role of law and economic analysis, basically to allow a society to achieve all these objectives of women's safety, reduce crime against women, but keeping in mind the other side of it, so that we can take more evolved judgments. Thank you. Thank you so much.
Thank you so much, sir, for your insights. Lastly, I invite Ms. Saubhagya Bhattacharya to deliver the vote of thanks.
Thank you, Ms. Chelsea. I put my regards and gratitude to the chair, the speakers of this panel, moderator madam, and the audience. Professor Avinash Dadich focused on policy perspectives, especially the Pradhan Mantri Jan Dhan Yojana and its success rests on the Aadhaar system, its confluence of technological and legal innovation. He remarked that India has the potential to create something big and beautiful through integrated policy making. And of course, sir, we will witness Viksit Bharat in 2047. Professor Dr. Yogendra Kumar Srivastav reflected on accessibility and equity, noting that essential services such as hospitals often remain out of reach for the working class. He stressed the importance of regulatory frameworks, citing the digital personal data protection as an example. Thereafter, Dr. Hitesh Thakkar examined the intersection of law and economics, describing them as disciplines that ultimately seek common objectives, which are efficiency and justice. He further elaborated creditor-debtor relationship and the dynamics of payments for goods and services, underscoring how both legal and economic systems must work in tandem for effective governance. Thereafter, Shri Kushal Kumar delved on the role of judiciary in changing world, especially in the digital era. In a short span of time, he focused on new laws and changing dimensions of existing laws, shaped according to the change in society. The chair, Professor Rao, for the panel discussion, beautifully put across the concerns of common man, including distribution of wealth and their aspirations from Viksit Bharat. Dr. Ram Singh, chair to this panel discussion, focused on information asymmetry and use of technology in policy considerations, focusing how economic analysis can help drafting the policy. I thank all the participants, especially the ones putting across questions, making this a fruitful discussion. I once again thank everyone present here, the panel, the panelists, the moderator, Madam, Chelsea, and everyone present here. Thank you so much for a patience hearing.
With that, we formally conclude this panel. We thank our chairs, moderator, and panelists for an enlightening discussion and all attendees for their active participation. We now break for lunch. Enjoy your meal and let the conversations continue informally over the table.
तुम अपने गेस्ट को लेके जाओ गेस्ट हाउस खाना खाने हम गेस्ट
Venue for lunch is guest house.
पूजा क्रियावत नाम का सेशन टेक्निकल सेशन 2 में है। हाँ, शी इज द मॉडरेटर। हाँ, तीनों साथ में करेंगे। हाँ, जैसे यहाँ पे है इंद्रेश सर, कौंडया और मैं, ठीक है? तो बीच में कौन है, चेयर कौन है इसकी? युगेंद्र सर। हाँ, युगेंद्र सर विल बी इन दी मिडिल। एक साइड पर हो जाएंगे एसपी सिंह सर और दूसरी साइड पूजा मैम। प्लेकार्ड वैसे प्लेस करेंगे। बीच में हो गए लोग नहीं दिखाएंगे। मतलब वहाँ पीपीटी रहेगा यहाँ पे, यहाँ से ये वहाँ इसके देखने में तो आएगा नहीं, या तो उसको ये माइक देना पड़ेगा, वही मैं बोल रही थी कि प्रेजेंटर उस साइड रहेगा, हाँ फिर वो मूव कर सकता है. आई थिंक इट्स बेटर दैट वी गिव हिम वॉकिंग
क्योंकि जजेस भी यहीं पे बैठेंगे.
हाँ क्योंकि वो वहाँ पे है तो पोर्टेबल माइक से ही कैन प्रेजेंट ओवर दैट. चेयर हट गई ना वहाँ से,
हाँ जी.
विजन क्लियर है, तो वहाँ पे खड़े हो सकते हैं. वो दोनों जगह चाहिए होगा,
तो दोनों जगह रखवा देते हैं.
रखना तो दोनों जगह चाहिए. If we don't have glasses तो एटलीस्ट उधर और इधर हो जाए, मेरे लिए तो ठीक है.
चलो ग्लासेस.
Because glasses I don't think so है क्या?
देख लेते हैं. अगर नहीं है तो बॉटल रख देना.
ठीक, परफेक्ट. बॉटल वहाँ रहने दो, ग्लासेस यहाँ हो जाने दो. ऐसा कर लो, बॉटल वहाँ रहने.
एक काम करते हैं, यहाँ पे बॉटल्स भी रख देते हैं, वहाँ पे ग्लासेस रख.
हाँ वही मैं कह रही हूँ.
अगर उनको चाहिए तो हम लोग
तो बाद में ग्लासेस पास कर देंगे सही, क्योंकि फिर वो यूनिफॉर्म नहीं है.
एक मिनट. कितने हैं? बस 3 ही है ना.
हाँ हाँ
ठीक है. बुलाएंगे मैडम. 3:30 हो रहा है ना, शुरुआत करेंगे.
ऐसा हाँ हाँ.
We'll call very Vikesh.
हाँ
He comes, we'll start. Because delay becomes delay to night. दूसरा we have the remote ना, यहाँ से हो सकता है PPT.
हाँ वो चेंज होगा. Sir, presenter will be here.
Okay. Mic? We don't require.
The mic.
They have the mic, no.
Yes, sir.
For me, no, because our voice will go up to there. Don't
Yes,
worry.
sir.
But our
Sir,
classes
please,
में.
yes, yes,
So we late हो जाएगा, 3:30 हो गई. Then after this, there one more session is there, no?
But that's in another room, sir.
4:15 cannot here.
Sir, the sessions are being conducted parallelly, so till 5:30 both the sessions will be done.
So we have ample time.
Yes, sir.
Then no problem. I thought there is after this there is a session.
No.
Then we can start leisurely. We can give as much time. We have only one session, right?
Yes, sir.
I was thinking that after this you have immediately a session.
Earlier had that plan, now it's
Changed.
now it's parallel. One in classroom.
In the program it is not there actually.
Yes.
बैठ के तो पता है सुबह 2 घंटा बैठ के आए गलती बोल रहे हो. Cyber last student? No. We don't have BBA, no? Only BA position or BS and MBA. I had I thought 2:30. So I had 1:15 cut. We come our own jobs, no? So people have their own work.
I've called for you to come in here.
The others will be passing those who complete it. And the participants will be, if you complete it, you can go Bhopal at other places. अभी भाई भोपाल है तो नहीं है. Same current. My PPT I will be tomorrow. I have a presentation. ज़्यादा टाइम लगेगा. यहाँ एक आप मुझे कर रहे हैं. You outside this place, you have to carry your own materials. Be careful and complete and go professional. Time में जाना. You have to go delay any part of the work. You should be our time and our job. No, I have to call those. उसमें क्या? I also have my own schedule. Nobody was there.
Mic on. I would request participants to take seat. Good afternoon all. I, Surbhi Tiwari, Assistant Professor of Political Science, on the behalf of National Law Institute University, Bhopal, would like to welcome you all for the technical session 1 on legal reforms for empowerment and economic growth. At the very outset, I would like to extend warm welcome to the esteemed chairs, Professor Dr. Kandaya J. Jonal Gadda from Maharashtra National Law University, Chhatrapati Sambhajinagar, and Dr. Hitesh Kumar Thakkar, Assistant Professor of Economics from Gujarat National Law University, Gandhinagar. I would request the chairs to please take seat on stage. Professor Dr. Kandaya J. Jonal Gadda is a distinguished academician with over 2 decades of teaching and research experience in the field of law. His areas: law, securities law, international law, and competition law, reflecting both depth and versatility in legal scholarship. He is gold medalist in his Masters of Law from University of Madras. He has been recognized with several prestigious academic honors, including the L.C. Miller Medal, Dr. A.L. Mudaliar Prizes, Justice M.N. Rao Prize, the Best Student Award in ML by the Mylapore Academy, Chennai 2002. Throughout his career, he has demonstrated an unwavering commitment to the academic excellence, rigorous research, and advancement of legal education, earning respect as both a scholar and mentor in his field. I would request Dr. Padma Singh Ma to kindly come to the stage to present mementos to our chair. We also have with us Dr. Hitesh Kumar Thakkar, GNLU Gujarat. Dr. Hitesh Kumar Thakkar is an assistant professor of economics at Gujarat National Law University, Gandhinagar. With over 15 years of teaching experience at undergraduate level and more than 4 years at postgraduate level, he holds a PhD, MA, BA in economics along with GSLET and UGC NET qualifications, and currently supervises multiple doctoral scholars. His research interests encompass global financial regulatory system, global financial crisis, global financial integration, macroeconomics, money, banking, and public finance. Law and Economics, reflecting a sustained engagement with the evolving intersection of law and economics in both global and domestic contexts. In recognition of his academic excellence, Dr. Thakur was awarded the prestigious German Academic Exchange Service Scholarship for a study and research exchange program at University of Cologne, Germany. His contributions to teaching and research were also acknowledged through Dainik Bhaskar National Education Leadership Award 2013, where he was honored as the best teacher in economics. He continues to lead and co-investigate several major research projects funded by ICSSR and Government of Gujarat, addressing areas such as insurance services for the persons with disabilities, accessibility in banking, and corporate insolvency resolution process in Gujarat. I would now request ma'am to kindly felicitate. Thank you, ma'am. Thank you, ma'am. We look forward to the engaging and thought-provoking discussion now. I would now request Rapporteur Ms. Raj Lakshmi to state the rules for the session.
Good evening to the esteemed panelists. I will be the rapporteur and the timekeeper for the session. And the rules are as follows. Each presenter would have total of 12 minutes, which would be bifurcated into 10 minutes for their presentation, and 2 minutes would be reserved for the discussion and question and answers. I would also be timekeeping, and I would raise the placard wherein 5 minutes will be left, when 2 minutes will be left, and finally when the time is up. I would now request the judges to kindly take the seat over there so as to facilitate the presentation. Yes, please.
The first presenter today we have is Pratima Shukla, PhD scholar. The title of the paper is Understanding Multiple Dimensions of Poverty in India, a comparative study at the state level. We would request her to please come for the presentation. Do we have Ms. Pratima here? Okay.
Hello. Good afternoon to our esteemed panelists, faculty members, and all the research scholars and dear students. A very good afternoon to all of you. I, Pratimas Shukla, a research scholar from Humanities and Social Sciences Department of Imperial University, Lucknow. So I'm here to present my paper, Understanding Multiple Dimensions of Poverty in India, a comparative study at the state level. So as we all know, that whenever we talk about poverty, we consider income and consumption. So बहुत ही अगर हम लोग पहले से देखें तो जब भी हम पॉवर्टी की बात करते हैं तो वी ओनली टॉक अबाउट कि पॉवर्टी अगर है तो गरीबी. सो हम इनकम देखते हैं कि इनकम कितनी है एंड उसका कंजम्पशन पावर कितना है. सो दिस इज़ वेरी नैरो टॉपिक. सो बेसिकली my paper, it shifts the focus from narrow to deeper. Today we will be understanding multiple understanding of poverty as introduced by UNDP, United Nations Development Programme, and OPHI, Oxford Poverty and Human Development Initiative. India through Niti Aayog has officially adapted this approach in the National Multiple Dimensional Poverty Index, which uses the data from NFHS 4, that is National Family Health Service Survey, which held in 2015 and 2016, and NFHS 5, National Family Health Survey 5, which held in 2019 and 2021. So basically, multidimensional poverty has three main indicators: health, education, and living standard. Excuse me. The objective of my study is to analyze indicator-wise changes in the states. Basically, I have taken state Bihar and Uttar Pradesh. So the first objective is to analyze the indicator-wise changes in both the states between NFHS 4 and NFHS 5. And secondly, to compare the rate and depth of the poverty reduction and identify the policy implication that emerges in both the trends. The indicators which I have taken, the first one is health, and under health I have considered nutrition, adolescent mortality, and maternal health. The second one is education. In education, years of schooling and living standards, cooking fuel, sanitation, electricity, and assets. The finding states that both Bihar and Uttar Pradesh have made notable progress in reducing multidimensional poverty. According to Niti Aayog MPI data, Bihar's poverty rate has been declined from 51.89 in NFHS 4 to 33.76% in NFHS 5, and Uttar Pradesh reduced from 37.68% in NFHS 4 to 22.93%. Despite the improvements, Bihar remains India's poorest state in multidimensional terms, with higher deprivation across almost all the indicators. According to the NFHS 5 reports and Niti Aayog report, Bihar is ranked first among all the states in multidimensional poverty. For example, if we consider nutrition as a deprivation, so nutrition deprivation stands at 42.20% in Bihar compared to 36.43% in Uttar Pradesh. The sanitation deprivation is 50.78% in Bihar, whereas Uttar Pradesh has improved to 31.61. In cooking fuel, 63% of households in Bihar still depends on traditional fuels, and compared to 52% in Uttar Pradesh. In maternal health, education, and electrification, both states have seen meaningful progress, reflecting the impact of government initiatives such as Pradhan Mantri Ujjwala Yojana, Swachh Bharat Mission, and Saubhagya Scheme. Policy implications and solutions that can be considered. The first one is targeted nutritional programs. For example, we should strengthen the policy which is Poshan Abhiyan, so that more and more, 5 minutes left. So to integrate people with local food supply chains and ensure food diversity, and increase investment in primary health centers which can ensure maternal and adolescent health care, because in most of the rural areas and remote areas people usually lack the medical facilities, and which increases their adolescent mortality. And PM Awas Yojana and Ujjwala Yojana, which again is useful for housing quality. So I would like to conclude my paper with India has made a sustainable progress in reducing multidimensional poverty, falling from 24.85% in 2015 and 16 to 11.28% in 2019 and 21. The state level disparities remains the same. The comparison between Bihar and Uttar Pradesh reveals that although both states are improving, but depth and intensity of poverty still remains the same. To truly achieve the sustainable goals, my paper relies on SDG 1, Sustainable Development Goal 1, which is no poverty, and Sustainable Development Goal 3, that is good health and well-being. Thank you.
If there are questions, they are welcomed. Thank you.
Thank you.
Next presenter that we have with us is Isha Kumari and Dimple Dhruv. Next presenters are Isha Kumari and Dimple Dhruv.
Should we mic on? Good morning, panel members and my fellow participants. I, Isha Kumari,
And I, Dimple Dhruv.
we are here to present on the topic of empowerment through law, strengthening tribal communities' labor rights and economic growth. Our theme of the presentation is legal reform for empowerment and economic growth. Now start with the introduction. Law is not a system of rule. It is a tool of empowerment that protects rights, restore dignity, and promote inclusive growth. In India, the role of law becomes very important when we look at the tribal communities and workers, because they are among most vulnerable groups at the same time. Their empowerment is directly linked to the economic growth and the country development. Legal authority or power to do something on their own. Next slide. Understanding economic growth in the context of tribal communities and the labor rights. In India is the world's fastest growing major economy and the fourth largest in the term of nominal GDP. Economic growth refers to the sustained increase in the production of goods and services in an economy over time, usually measured by indicators such as GDP per income and the level of industry and agriculture output. Tribal, who are guardian of natural resources and workers who sustain industries and agriculture, must be centered to any definition of growth. True economic growth is thus not only about the higher output, but also about creating a society where progress uplifts all particular segments of vulnerable groups. India is a land immense culture, ethnic diversity, with over 700 distinct indigenous communities, officially recognized as a scheduled tribe under Article 342 Indian Constitution. Next slide. The Constitution of Foundation for Labor Rights. Article 21, right to life. Article 23, right to against exploitation. And Article 43, for living wages for all workers.
Article 19, Clause 1, Clause C, freedom of association, that guarantees right to form unions and the associations. Article 39, Clause D, the constitutional directive principle, the state policy mandate, states should ensure equal pay for equal work for both men and women. Article 14, guaranteed equality before law and the equal protection of laws. Article 16, ensure equal opportunity in the public employment. Next slide. There are three pillars of workers' protection. Fair wages should be provided, social security should be provided, and the safe conditions. Next slide. The vulnerability of the informal sectors. There are many issues: low wages, job security, poor living, and working condition. COVID-19 crisis exposed that there is only 1.8 GDP in health in India. The COVID-19 migrants labor crisis saw the dangers of neglecting labor rights as millions of workers were left without income or protection, destabilizing both families and the economy. Where workers are empowered, they have formed a stable, skilled, and productive workforce. This outcome proved that the social justice and the economic growth are not opposing goals, but mutually reinforcing ones. Next slide. Lastly, key legal cases shaping empowerment, landmark judgments. Firstly, Bandhu Mukti Morcha versus Union of India, in which the Supreme Court held that constitutional right to dignity and safe work for the bonded laborers. They expanded Article 21, right to life, to include labor protection and the dignity of workers. Samatha versus State of Andhra Pradesh, in which protected tribal lands in scheduled areas from the private mining corporation, ensuring that the non-tribal people transferring not the tribal land. Niyamgiri case upheld the Gram Sabha authority to determine forest right and provide informed consent for the development project and strengthening local governance. Now move forward to
Now let's talk about the constitutional safeguard for marginalized group. The Indian Constitution provide a solid foundation for protecting the rights of scheduled tribe. Article 46 promotes their educational and economic interest. Article 30 and 32 ensure their educational and economic interest. Article 46 promote their educational and economic interest. Article 244 with the 5th and 6th schedule gives them autonomy in governance. Article 338A created a National Commission for Scheduled Tribe to monitor safeguard. This provision aimed to ensure dignity, equality, and justice. This provision are not favored, they are constitutional right. But still they are not aware of this constitutional provision. Next slide. Land rights and legal protection. Land is not just a property for tribal, it is identity, culture, and survival for tribal community. Over the years, several strong laws have been enacted to protect the right to tribal community, such as the Forest Right Act 2007, the Panchayat Extension to Scheduled Area Act 1996, the ST/SC Prevention of Atrocities Act 1989. These laws were meant to secure their land, preserve their culture, and ensure self-governance in their traditional area. But the reality tells a different story. Thousands of tribal families are still being displaced from their ancestral land in the name of development and industrial projects. Their sacred forests are destroyed, their livelihood are taken away, and their voices go unheard. Next slide. Challenges and gaps and implementation. The real problem is not the lack of law, but their poor implementation. Though India has a strong law and act like Forest Act, Panchayat Extension to Scheduled Area Act, their benefit often remain stuck in paperwork. Thousands of claims are pending, and many tribal councils lack of real authority due to poverty, fear, and legal unawareness. Most of people cannot claim their rights because they don't know. Our goal should not be to create more law, but to make existing ones to really work for the people. Next slide. Programs transforming law into economic outcomes. Several government projects are helping turn legal rights into real economic empowerment. The Manrega guarantees 200 days of paid work. The Pradhan Mantri Kaushal Vikas Yojana trified Vandhan Vikas Kaushal. This initiative shows that when law combines with policy and participation, people live improve income security and skill development together build confidence, create opportunity, and lead to inclusive, sustainable growth for tribal and labor communities. Next. Policy recommendation for inclusive growth. To achieve real empowerment, strong policies and effective action are essential. First one is the government must ensure full implementation of Forest Act, Panchayat extension for scheduled area to protect land and self-governance. Second one is promote eco-friendly industries like organic farming and ecotourism in tribal area. Launch legal awareness campaign to educate people about their rights. Simplify access to justice through legal aid. Social security to cover informal and migrant workers. These steps will ensure inclusive, fair, and sustainable development for all. Now hand over to Isha.
Lastly, conclusion. Law as a catalyst for equity and the growth. This study demonstrates that law play a critical role in empowering marginalized groups, protecting labor rights, empower communities and secure worker, create strong local economies, preserve natural resources and build resilience in the face of social and environment challenges. That inclusive policies such as Manrega, skill development programs and Vandhan Vikas Kendra illustrate how legal frameworks combined with the government initiative and can provide livelihood opportunity, reduce poverty, and strengthen social security. Only then can law achieve their goals of protecting rights and enabling inclusive growth. Thank you.
Thank you. Are there any questions? No. Thank you. Next, we have Dr. Sachin Bharadwaj and Sherry Pant.
Good afternoon to you all, respected chairs, co-presenters, as well as the presenters here, faculty members. I am Sherry Pant, Assistant Professor, Karnavati University, and along with me is Dr. Sachin Bharadwaj, Assistant Professor, NMIMS Indore. So the paper we are presenting here is From Kolhapur to Italy, Rethinking Empowerment Through Equitable Benefit Sharing in Traditional Knowledge. So traditional knowledge embodies a cumulative wisdom, skills, and practices that is passed through generations of indigenous and local communities. This traditional knowledge is deeply rooted in ecosystems, cultures, rituals, and oral traditions reflecting harmony with nature. It is recognized today for both of its cultural advancement as well as it has some scientific value to it, also some economic benefit. And the statement of the problem our paper is presenting is that the indigenous communities remain economically and legally marginalized. The corporations often exploit traditional knowledge without fair returns. The laws we are having right now in India, for example, the Biological Diversity Act of 2002 and the Geographical Indications Act of 1999, they lack effective enforcement. The traditional knowledge digital library and the geographical indications protect knowledge but not the community rights. There is a power imbalance that causes cultural loss and exclusion. And thus, there is a need for fair participatory benefit sharing systems. The objective of the study of ours is to examine legal institutional mechanisms that protect traditional knowledge in India. Then it is to propose reforms for equitable benefit sharing and empowerment of indigenous communities. And our paper structure goes like, we start with the abstract, obviously, then the introduction, we have a literature review, then there is a description of the legal and institutional framework. We have certain case studies to support our findings. We identify the gaps and limitations. There is a recommendation, and finally there is a conclusion. Over to you.
Thank you, Ms. Seripant. So just briefly, I hope that you must have understood the main statement of problem of the topic. The matter arose when recently there was a case related to Kolhapuri Chappal and Prada. So the basic point here is this, that the traditional knowledge must be protected. So these TKs are protected in terms of different IPRs, like geographical indications, like patents, like turmeric and neem are protected under patent law. So here, before moving to the main issue and the case study of Prada, which will be discussed with my co-presenter, I will be having a little glance of the legal framework. So because that is the main concern, that we are relying on some legal frameworks, but still we are lagging behind. We are not able to give the equitable benefit sharing to the people who are really cultivating, who are really conserving that particular tradition knowledge. So if I talk about this particular thing, so basically we have taken or we have adopted that particular law from different conventions. So if we talk about in India, the law basically comes from the Biological Diversity Act. So there is a multi-level protection are provided. So there are national, institutional, and international frameworks are there. And the basic objective is to regulate the access, prevent misappropriation, and ensure equitable benefit sharing. So the main point I would like to point out this ABS, equitable benefit sharing. And thereafter balance community rights, biodiversity conservation, sustainable use, these are the things. So this is the main act, Biological Diversity Act 2002. So this particular act is having three kind of setup, because if we are having law, we must also have a kind of authority for the implementation purposes. Otherwise, there is no logic of having a particular law. So there are three-dimension authorities are there: National Biological Diversity Authority, State Biodiversity Boards, and Biodiversity Management Committee for for local level. And next act is Geographical Indication Act. This particular act is basically protecting the traditional knowledge on the basis of a geography. Suppose here we are talking about the Kolhapuri Chappal. So this Kolhapuri Chappal has been protected under a GI. So it has been provided a GI tag. So this particular law, but this particular law is lagging behind in terms of giving protection at the international level. Though there are, if we talk about some international aspects also, that will be covering in the next slide. And there is a particular proposed TK bill that was proposed in 2022. So in that particular act, the government have attempted a little bit to provide that particular equitable benefit sharing framework, and they have provided certain definitions like custodian. Suppose I am having a particular kind of traditional knowledge and I am the custodian of particular plant or any method, so I will be taking care of it. But the ownership will be in the hands of government. So that is again a question comes the power imbalance, that why the government is taking the ownership of a thing. Suppose, for example, if I have a house, so I will be the owner of the particular house. Though the government can ask me to pay some taxes, but I will be the wholesale owner. But here the government is making those people as custodians. But this particular act has not been enacted now. This was a bill which was proposed in 2022. Next is the National Biological Diversity Authority. That is that we have discussed in the earlier slides. Now we comes to the international framework. if we talk about the international framework, we are having two international framework, Nagoya Protocol and Convention on Biological Diversity, and from which we are having Biodiversity Act. So the main thing is that that particular convention is totally depending upon the state. Suppose if India ratified it properly, India implemented it properly, then we will be able to cover it. Otherwise, we will not be. So it is totally dependent upon how a particular country or state implement it. So these are the two laws. Next is the TRIPS. So TRIPS, we are also having the TRIPS agreement, but there are some limitation in the TRIPS as well. Because TRIPS is providing overall a broad framework, a broad outline, but the main wholesale responsibility is of the state to implement that particular thing. So this particular case study will be dealt by my co-author.
All right, so let's meet the Kolhapuri Chappal case study. So this Kolhapuri Chappal here is a unique symbol of heritage and artisan and livelihood, and it is a very labor-intensive process to create it. You can see the intricate details here. This is hand braided. This is fully handmade, and there is a vegetable tanning involved here. In the terms of the Marathi artisans that those make it, they say that चप्पल को टिकाने के लिए क्या करना पड़ता है. तो the weaving itself here, it takes around 36 hours, they claim. So this has secured the GI protection under the GI Act 1999. Yet there were certain problems with it. For example, in 2025, Prada launched a sandal resembling the Kolhapuri design. You can see the image here. This is a photograph from their fashion show where they demonstrated their design. Now, the issue comes that no consent whatsoever, or nor any credit or benefit sharing was given to the Kolhapur artisans. Then comes the issue that this incident itself exposed limitation of GI protection and enforcing rights beyond the national borders. Definitely, GI Act of 1999 is protecting the Kolhapuri Chappal by giving the GI tag, yet the protection ends at the borders. One more thing I would like to add here is that a Kolhapuri artisan is not even able to get 1,000 rupees, yet the Prada is aiming to sell this chappal at around 1.5 lakhs. This highlighted need for stronger international cooperation on traditional knowledge and GI enforcement. Along with this, this led to call for greater IP awareness among artisans for institutional and economic empowerment. And this reflects the gap that we are highlighting here, the gap between legal frameworks and on-ground benefit sharing. Next is the case study of Kerala's Kani tribe.
So just to support that particular Prada case study, there were some case studies like Kani tribe. I would just like to quote this particular thing, that there was a plant called Arogya Pacha in Kerala. So there was an incident where some of the one of the researcher who was traveling in the hilly area of the hilly forest area of the Kerala. So they were not taking any kind of rest. But the researcher, or the we can say one of the professor, I would not remembering that particular name. So he just out of curiosity, he just asked a question that why you people are not feeling. Why you people are not taking any rest? So they just describe a kind of plant that we just chew the leaves of a plant called Arogya Pacha. So by using that particular leaves, they created a medicine called Jeevni. And that particular product was called, that particular product was used on wider scale. And the business was also reached at the particular certain level. But the main concern here is that the main concern is about the equitable benefit sharing. Because the main people who are conserving that particular plant must have the equitable share in terms of finance, in terms of budget, in terms of money, or in terms of a conservator protection. So that particular thing they could not give, they were not able to give properly. Though though the particular raw material which was being sent to the particular some other countries like US, that US is also having the access of the same material, but they were not able to find out how the material is being sent to the US. I can take 1 or 2 minutes more. Okay, I'm just concluding. So there's a particular turmeric case. So in the turmeric case, and another case study is of neem. In both the cases also, India fought at the US and that particular, though we are having such kind of traditional knowledge, but still we have to fight and we have to spend a lot of money in US just to prove that this turmeric and neem is belonging to India. So these are the case studies. There are some gaps and limitations are there that we are not having particular framework on equitable benefit sharing. Main point is that we are not having a exact parameters or at the framework that how we are able to do this equitable benefit sharing. These are some recommendations that legislative reforms and definition clarity that was indicated in the bill also. Benefit sharing mechanism and monitoring framework. Third is institutional strengthening and capacity building, international engagement and advocacy, social cultural empowerment. So these are the very fancy words, but if we come to the implementation, this will take a lot of efforts. But if we do some effort, then it will be possible to give some equity to the people who are really conserving our traditional knowledge. Thank you so much.
Thank you. Any questions?
Any question regarding?
Yes, there's one question.
Though there are, the Indian government has taken one initiative like traditional knowledge digital library. So where the government has published around 4.64 lakhs methods or medicines or any kind of other certain herbs which are documented. And India has given the access to the 15 to 16 more countries that if they want to use, then they have to do a certain kind of research. If they find that India has already documented this particular method, so they cannot use. But still, suppose if I am doing some kind of research and creating some method or herb, in that case, if I belong to a particular community and that knowledge is being spread only to 10 or 12 people, so there must be some method or some framework that the advantage must go to these people, at least up to a certain extent that they can, suppose in that particular case, there was no credit was given, but after a few pressure was imposed, then the Prada accepted that we have taken inspiration from Maharashtrian Kolhapuri Chappal. Okay. Okay, thank you.
Thank you. Next, we have Abhinesh Soni for the presentation.
Hello, am I audible? Yeah. So, I take the liberty to begin with the theme of our conference, Synergy of Law and Economics Pathways to Viksit Bharat 2047. Now, for any nation to be called as a developed nation, what could be the most important factor? It could be, and it is definitely the growth. So, my question here is the growth wheel really rolling for us? And that is my research paper for today. So I explain you first why this topic, growth without justice, is unsustainable. So as per my research, we are growing, our GDP is growing as a thumping rate of 6.5%. We are the fourth largest economy, but yet there is a paradoxical growth that we are facing. At the time that when GDP is growing, GDP is growing. We are experiencing global low ranking in terms of global capital, in human capital index, wherein we are ranked poorly. Our social inequality is rising. There's a disparity in income, there is a disparity in wealth, there is a disparity in growth rate, gender gap. And that is why the question comes, what is GDP overlooking? GDP is growing at a sustained rate, but at the same time, it is accumulating lot of inequalities within itself. There has been inequality in, as I told you, about gender, there's inequality about region, and I'll come across when I'll explain how grave the situation is. Yeah. So here is the basic purview of all the factors that that India is experiencing right now. When we talk about the income distribution in India, we see there is a top 10% of the Indian population holds about 57% of the income. Then the bottom 50% of the population only holds about 30% of the share. When we talk about the global index, as I've already told you, we are ranked 122 out of the 166 countries in the Human Development Index. When we talk about poverty index, we'll see that some of the states of India have a poverty rate that is much below than some of the lower countries of African countries. Whereas some of the states like Kerala are experiencing poverty rates which is far better than some of the developed countries. So there is a disparity that is what I'm pointing out with my research data. And specifically, I want to point out about the gender inequality, wherein only 15% of the women are in the workforce when they contribute about the 50% of the labor force. There is a huge gender gap between the pay of women and men when they come into the working force. And also, as the guest of honor has pointed out in the morning, the alarming rate of the health ratio in the country, wherein only 20% of the rural populations have the medical facilities, while all of the resources are accumulated in the urban area, wherein rural population contributes about 55% of the population of the country. So this itself is very alarming, considering the disparity between the haves and haves not in the country. Now, let us see what other countries are doing, what we are not doing, what developed countries are doing. Developed countries are spending their income, spending their share in the human capital index. They are spending their money on the insurance, they're spending their money on the healthcare. And that is why they are yielding profitable result, wherein even if their GDP rate is small, yet their overall growth rate, their Gini index are much more because of the fact that there is a sustainable investment in the human capital investments, which draws me to the point that we also make generate lot of income, but that income is wasted in the forms of freebies, in the form of free grants that was earlier talked in the opening session of us. And that is exactly what my paper deals with, that there is growth, but there is disparity. I also have taken example from the Latin American countries, wherein they have introduced some measures which have contributed significantly in reducing their poverty gap, in creating more equitable distribution of the resources. Some of the examples are Chile. Chile has introduced a progressive inheritance tax for the rich, which has resulted in reduction of wealth accumulation by 25%. Brazil has opted for a distribution of a cash system, wherein if there are certain criteria that are being met by the population, if their children are going to the school, if they are using the health resources, thereby they are distributing cash to the population. Not irrespective of the fact whether that population is rich or poor. Wherein in India, irrespective whether they fulfill the condition or not, free visa given. So there is a stark difference between these countries or not. With these, I do not say that Latin American countries have completely moved to the path of development, but they have introduced measure. The whole point of bringing these countries on the presentation or on the research paper was that they have introduced certain measures which have been benefited by them. Not completely, but they have been able to reduce some of the income disparities or the disparities that they were facing. For example, Colombia was experiencing land problems, so they have introduced a land reduction wherein they have returned 1.5 million hectares of land to the poor population. With this, I take inspiration from them, and I take what can India do to achieve some of the developments which can help in reducing the social inequality that we are facing. Firstly, a progressive wealth taxation. So our taxation system should move from growth in a form of tax to the form of equity-driven tax system, wherein rich should be taxed more. I mean, they are doing more, but there should be inheritance tax as well, because this is completely not taken care of. Also in India, I have researched upon that there is a large unequal distribution of land that is prevailing in the country, wherein majority of the rich people or wealthy people are enjoying major chunk of the land. So these kind of measures are necessary, wherein we sort of bring ceiling laws or introduce measures where there can be redistribution of the land. And then there is combat tax evasion. So with this, I want to talk about adopt OECD BVP's framework. What is this? Is a lot of MNCs, what they are doing is they're generating profit from the developing countries, but they are giving these profits to the lower developing countries where there are low tax rates. So they are reaping profits from us, but they are giving profits to the lower countries where there are low tax rates. So this is a mechanism where there is a global tax system wherein our cumulative tax can be levied upon these MNCs so that the profit stays in the country where it is generated. Apart from this, we also have to adopt the SDG solutions that have been convened upon by the UN and the ILO conventions that have been convened upon by the International Labour Organization. So these are some of the measures that can be undertaken by our country if we really want to get into the path of a developed nation by 2047. Otherwise, solely relying on the fact that our GDP is growing, chest thumping that our GDP is growing, we are the 4th largest economy, that will not help. And one important thing that we also have to take care is considering the fact how our legal system is working. I would like to draw the very important attention about how the conditions are prevailing in the jails. The jails are overcrowded. There are 120% population, overcrowded people who are awaiting trials in the jail. So the distribution of resources and should be in such a way that these people also get right to justice. Otherwise, there is a lot of expenditure that is going on these people who awaits trial, and it's a frivolous expenditure on our part. So such kind of measures are also important because this will never be talked about if we consider the social economic balance that we have to achieve. I'll wind up. Apart from this, we also have been introduced with some of the social initiatives such as the Pradhan Mantri Jan Dhan Yojana. Such kind of initiatives are important. There are other yojanas as well. I'll not go into the details because considering the time constraint. So my nutshell or conclusion of all of what my presentation is, we are living in kind of a hoax growth, which is not parallel to the vision that has been drawn in this conference to achieve a sustained and a developed nation by 2047. That goal is still a far-fetched dream for us if we do not work upon the social inequalities that are existing in our country. I'm open to questions. Thank you.
Thank you. Do we have any question? If chairs would like to ask any questions.
Actually, a suggestion, page number 9 in a paper, no? You recommended the duties to a directors about the CSR and environment. It is already there.
Yes, sir. They are there, but they are not strict implementation of penalties or if they do not fulfill.
It is there, it is there.
It is there, sir, but yet there are lacunas. They take up the CSR initiative.
Not
but
CSR. You said about director should have a fiduciary duty to environment,
yes, yes,
right?
your lord. I stand corrected on the director's
that
part.
one, because
Yes,
section
yes, yes, sir.
166 class 2.
Yes, sir, yes, sir.
Earlier it was not there.
Yes, sir.
In 2013 Act they made
Yes,
compulsory.
sir. For CSR initiative, they do a sort of a second lead role wherein they shift, they adopt measures which are not completely social.
So CSR I'm not you talk
Yes,
about the
yes, sir.
fiduciary duties.
I stand corrected on that.
There expressed provision in 166(2).
Yes, sir.
Duty to community and environment.
Yes, sir. Yes, sir. I
So
stand
that,
corrected on
okay,
that.
that you can, when you are going to revise the paper, you just make a
Surely,
correction.
sir.
on
Surely,
that.
sir.
That is only just supplement.
Thank you, sir. Thank you, sir. Thank you so much.
Thank you. Now we have the next presenter, Jessica Mary Matthew.
Good afternoon to one and all present here. The topic of my paper is harmonizing tax policies with intellectual property rights, building innovation pathways for Viksit Bharat 2047. So India's aim towards Viksit Bharat 2047 requires a strategic roadmap which showcases the synergy between law and economics to create a robust innovation ecosystem. The role of intellectual property rights is quite incremental in this journey. It not only acts as a tool for safeguarding creativity and innovation, but also acts as a driver of economic growth. However, its true potential can only be harnessed by way of effective taxation policies. So firstly, I'll be discussing the role of intellectual property rights as a facilitator of innovation and economic growth. So IPRs play a vital role in promoting innovation and economic growth. They grant the creators with exclusive control over their creative works or inventions, and they both provide both legal protection as well as economic incentives for the same. These act as strong incentives for individuals and organizations to invest in R&D and innovation. Next, I'll be discussing the role of taxation in promoting innovation and economic growth. So tax policies can be used strategically by countries to exert a significant influence on the economic incentives for innovation. These help governments in attracting businesses to their own territory and enhance competitiveness as it reduces a company's tax liability based on the amount spent or the investments made on R&D. So consequently, a well-designed tax policy is a must for countries aiming to foster business activity and economic growth. Implementing a differential and preferential tax regime for resident Indians can serve as a strategic tool to attract businesses into India and thereby promote innovation and economic growth. Next, I'll be discussing the interplay of IPR laws and tax laws. So as we know that patents, copyrights, and trademarks, they have the potential to be transferred. That is by way of assignment, licensing, etc. So these transactions, they incur tax liabilities. So by way of such commercialization, the right holder receives payment or royalty for their labor, but the society at large also benefits from the dissemination of their inventions or intellectual creations. Next, I'll be discussing the economic incentive theory. So, if we study law and economics or the economic analysis of law, it majorly focuses on two major points. First is on efficiency. So, efficiency is a principle which is very inherently relevant to policy making, as public officials generally seek to avoid wasteful allocation of resources. And the next thing is the next characteristic is the incentive part. So It assumes that individuals are rational parties who will adjust their behavior in response to a change in incentives. For instance, higher penalties for particular action will typically lead people to undertake less of that action. So basically, this theory motivates people to act by the expectation of positive or negative consequences. It explains how individuals and firms make choices by weighing the potential rewards against the potential penalties. The IPRs, they provide a prospect of reward, which in turn encourages creative and technological advance by providing increased incentives to invest in, and further develop new ideas. And without such, the invention inducement would be weakened. There are basically two types of incentives, if we see. The first incentive is a legal incentive, which is already provided by the law by way of patents, copyright, etc. And the second, the economic incentive, which can be provided by way of tax policies, which is also given in the Income Tax Act, like R&D tax credits, patent boxes, deductions, etc. They make innovation financially worthwhile. So as we can see, the IPRs, they focus basically, they provide the incentive after an invention has been created. But in the case of tax policies, they provide the incentive before an invention is created and also during that part. So the coexistence of IPR protection and favorable taxation creates what may be termed a dual incentive framework, wherein legal exclusivity and fiscal rewards function as independent levers in promoting innovation. So IPRs grant exclusivity and market control, and thus they serve as the first layer of the incentive mechanism. However, the high cost, uncertainty, and long gestation period associated with R&D often render these insufficient to fully motivate innovation. So the fiscal measures such as R&D tax credits, deductions, and patent box regimes operate as a second layer of the economic incentive, which complements the protection-based framework of IPR laws by offering immediate and tangible financial benefits. Next, I'll come to the IPR life cycle. So basically, an IP asset goes through three stages of three stages. The first is the developmental stage. It mainly includes the research and development part. Second is the exploitation stage, wherein the IP is being commercialized, that is, it is being licensed or assigned to somebody. And the third is the alienation or the expiration of the term of protection part. So alienation part will cover if the IP is sold to somebody permanently. Now, I'll be discussing the tax implications at every stage of the IPR life cycle. So in the first stage, as we can see, the developmental stage, the tax implications will be mainly the R&D tax credits, because that's basically the research and development part. So tax policies can be like government can provide R&D tax credits or other deductions for expenditures relating to R&D, know-how, etc. For the second part, which is the exploitation part, there are many, even in the Income Tax Act, many measures, there are sections relating to royalty income and how they should be taxed, and some benefits are also provided. At the third stage, which is the alienation stage, so this basically involves the sale or transfer of an IP permanently. So it will attract capital gains tax, and also this is also taxed under GST law. Depending on the case, it can be taxed as a supply of goods or a supply of services. So as most of you would have seen this particular movie, A Beautiful Mind, which is based on the mathematician John Nash. So he basically developed the game theory, which is a very famous theory in economics. So John Nash basically said that the best outcome doesn't always come from each player acting in pure self-interest, but when they consider the group's collective strategy. So this particular Nash equilibrium, it has changed economics, it has changed the way we see international relations, and also how we understand cooperation. And this approach I've also tried to incorporate into my paper. So countries which, while they're designing the tax incentives and innovators, deciding where to invest and commercialize their IP, they face a strategic game, much like the prisoner's dilemma. So acting only in self-interest can lead to a race to the bottom, undermining innovation and economic growth. So to conclude, as we can see that India does not have such an IPR tax framework till yet. So if India introduces tax incentives across every stage of the IPR life cycle, from creation and registration to commercialization and transfer, it can, to expiration of the IP rights, it can build a strong IPR taxation framework that encourages innovation, startups, and drives long-term economic development. So by aligning tax policies strategically with each stage of the IPR life cycle, they can serve as powerful tools for facilitating innovation and economic growth. By encouraging R&D, supporting commercialization, and ensuring equitable taxation of income from the IP assets, such policies have the potential to create an innovation ecosystem that rewards creativity and innovation without eroding the public revenues. Thank you.
Thank you. Do we have any question? No. So we now have another presenter, Aditi Ranjana.
Anushka is not there, Srivastava. No, no.
Good evening, respected judges and participants. I am Aditi Ranjana from ITM University, Raipur. And my topic is From Exclusion to Empowerment, Legal Economic Reforms for Tribes in Viksit Bharat 2047. My research explores how integrating law and economics can transform tribal inclusion from paper-based right to practical empowerment. So let's start with introduction. The vision of Viksit Bharat 2047 is not just about economic growth, but about inclusive development. Yet, tribal communities, one of India's most marginalized groups, still faces barriers in land rights, market, finance, and governance. Moving to the next slide. There is highlighted problem like legal, there are basically two highlighted problems, like legal exclusion and economic exclusion. Legally, rights exist on paper, but implementation is weak. Many lands and forest title claims remain pending or rejected. Economically, limited access to market, credit, and skill-based opportunities keep communities dependent on intermediaries. So while we have policies, the bridge between promise and practice is still missing. This data shows the ground reality under the Forest Right Act. Despite lakhs of claims being filed, nearly 40% have been rejected by state due to procedural and evidentiary gaps. This shows how systematic challenges persist even with a strong legal framework like FRA. Next, we have legal framework. India's constitution has built a strong foundation for tribal protection. Article 46, 244 and 275 along with 5th and 6th schedule ensures administrative safeguards. Laws like FRA 2006, PESA 1996 and ST-SC Act 1989 legally secure land, governance and protection rights. Even the Supreme Court in Samata and Niyamgiri upheld tribal autonomy, but actual enforcement is still inconsistent.
Here we talk about economic barriers. Economic barriers add another layer of exclusion. Tribal procedure of minor forest produce often earns the least, while intermediaries captures most of the values. Finance streams like tariff or TFDC exist, but access is low due to collateral issues and lack of awareness. Here are a few proposed reforms to bridge these gaps, like digital monitoring of FRA claims for transparency and speed, tribal entrepreneurship hubs to promote self-employment and innovation, local ADR and legal literacy centers in tribal language for quick dispute resolution, GI tagging and cooperative marketing for tribal products along with special credit windows. This reforms aims to build capacity rather than dependency. Next, we talk about implementation. Like from NGOs to state agencies, central ministries, the idea is to create shared accountability, where law, finance, and governance interact to deliver results rather than work in silos. Next, we have comparative insights. Globally, several models can inspire India, like Canada grants fiscal autonomy to its indigenous communities. Australia follows co-management of natural resources, while New Zealand Maori model blends legal recognition with economic participants. India can adapt these by giving tribes both legal autonomy and access to market. Here is the source, which includes official data from Ministry of Tribes and Affairs and others. To conclude, empowerment cannot be achieved through welfare alone. It requires participants, access, and accountability. The vision of Viksit Bharat 2047 will remain incomplete unless all tribal communities are not just protected, but truly empowered to shape their own development. As a developed India is only possible when every community grows together. Thank you.
Thank you. Do we have questions? No? So with this, we come to the end of the technical session 1. We had 6 presentations today. Now I would invite our chairs to share their observation in regards to the session.
Good afternoon. Yeah, firstly, on the backdrop of this conference, I would like to congratulate NLIU Bhopal for organizing this wonderful conference. And yeah, also congratulate to all the contributors, because it's quite tough to integrate economics and law, because generally people try to write things in the backdrop of law. Yeah, people try to write something in backdrop of economics. Now you have to write something in backdrop of integrated law and economics. I think it's significantly difficult. I think, yeah, so NLU Bhopal is doing quite well in the domain of law and economics. And yeah, it was a wonderful conference, wonderful papers. And yeah, so everything is good. So something has to be still required to be better, best, because world is moving in a different way in law and economics. So yeah, I will go one by one paper. I think firstly, all the papers were good. But like suppose if I was there in your place, then how I maybe have written the paper? Like, well, if you go with the multidimensional poverty, yeah, paper want to try to compare the the Bihar versus the UP. And well said data were there, and I think it was good that through data he was communicating, through evidence he was communicating. I think if I was there, I maybe have taken some conceptual framework. And when we are discussing something in legal policy context, I maybe have discussed something from the law and policy point of view. And what can be looked from both the state, because both states are indigenous, both states are different. I think I maybe have interacted with some policy makers, and then somehow, somewhere I maybe have concluded. Otherwise, paper is good pilot study. I think it can be further developed. A good conceptual framework can be developed. And also there's a possibility to develop a good legal framework. I think then it's possibly to publish in any good journal, whichever they deserve. Similarly, if you go with the environment through the law, strengthening tribal community labor rights and economic growth, I think, yeah, good job, yeah. Sometimes it's quite difficult to write from the law and economics, from this subjectical economics point of view. I think authors try to take legal framework, yeah. If I was there from the author side, I maybe have taken some very good economic concepts are there. If I take some of the economics relevant concept and then try to put the context of the law, already you are communicating everything. Just only there was a possibility if you can, you have tried, but if you have taken some additional data and try to put forth your analysis, I think it become more evidence-based. But the good starting, I think there's a possibility you have the overall structure and the possibility you can further develop the paper. Yeah, I was quite happy with the title, yeah, from Kolhapur to Italy. And yeah, I think your paper was having a very good continuity in story. Paper was quite good, well thought. Paper were taken some case studies and try to communicate. I'm not from law, I'm from economics, but still you have to re-look and re-talk to those people who know the law better than me. Because you are trying to communicate geographical GI versus traditional knowledge. There are also some concept of indigenous knowledge, whether the three are same or not. I think because there are skills and other things you are trying to protect, I think something additional things are there. I may be wrong, but I think law people can further substantiate, because yeah, I should not go and cross the territory of law. I think my colleagues sir will tell more about the law point of view. But yeah, the case studies was scientifically taken. Yeah, so that's good that you have taken the case study. But in your paper also, there is a possibility that you maybe have taken overall conceptual framework of the traditional knowledge. I maybe have developed one specific basic model, try to talk about that model and then come to that part. And yeah, if I want to publish in Scopus, and then I maybe have talked to some of the people who are there and maybe try to take the local opinion, and then I think I have been concluded if I maybe have got opportunity. But overall, it's quite title to have an overall story was also going quite well. Only the conceptual framework can be developed. I think if you can look into it, I think that will be quite great. Then yeah, growth without justice and unsustainable closing India inequality gap and almost urgent. I think first of all, I think I would like to congratulate the person. I think it's from the advocate and from the law point of view, writing something from the economic. I was thinking that you are purely economics person, you are writing something. So I think in that regard, it does make sense. But generally, just only paper was telling many things. But though you also know when you go to the court, you stick with the given the premises and the thesis statement. So concluding many things was not possible. Otherwise, the paper was communicating better. So if I may be there, if you have done that framework and already you are from law, I maybe come out with some legislative framework, broader legislative framework, not from Indian context, from the international context, and try to communicate something. Yeah. Yeah, harmonizing, yeah, this paper was quite good, yeah, harmonizing the IPR. I think this paper was having the conceptual framework. I think I was quite happy that you were talking something from the law and economics, maybe in efficiency, incentive, and even the game theory. But when the strong conceptual framework was there, I think it was not substantiating with the phenomena and from the ground level reality and the legislative framework. So I think your paper have some additional understanding from the economic theory point of view. So theories were there, and you're strongly communicating something. If I may be there, then I will back up something closely with the law and phenomenon context, and then I try to communicate, yeah, I try to conclude. I think last paper, yeah, from exclusion to empowerment. I have not gone through the complete paper, so I may not communicate, but I have seen your presentation. I looking from the presentation point of view, both the data analysis and their weather, because I have not seen the paper, so I can't communicate. But yeah, I hope that your paper may be communicating the given premises what you have said in this slide. But I think there is a possibility to adding the conceptual framework. All in all, I think, yeah, quite good job. In India, people are doing quite good work in law and economics, and I think things are becoming more tougher for the future generation. I'm good that I'm not competing with you, and I'm quite safe place, and in that regard, I may invite my chair to further to make his comments. Thank you very much.
Thank you, sir. Now we would request Professor Dr. Kandeya, sir, to share his remarks.
Good afternoon to all, and at the outset, let me congratulate all the presenters, or I can put it this way, researchers. And from the commencement itself, we have sometimes we are dividing, we are combining the subjects of law and economics, and I just want to start. There was also one comment in the inaugural session. When the Constitution was drafted, economics was not consulted. I want to make a correction on that, because there may be younger generation who are listening here, and it goes on the viral. Dr. Baba Saheb Ambedkar has done 2 PhDs on economics. One among the topper is the problem of rupee, and other, I'm not getting the name suddenly. So therefore, the father of the Indian architect, which we call the first law minister of India, is who drafted the Constitution, is the economist, then had a law degree. Therefore, law and the economics, I can say, both the 2 sides of a same coin, and we have to move on. So every subject has its own importance, and as a part of the curriculum and the field, we have divided for a curriculum. Otherwise, in the 5 years law curriculum, because I studied 5 years law, where the economics was compulsory paper, and I also studied one paper on law and poverty. Today we don't have that paper. And there was also one more paper when I was student of law, law and development. And law and development, law and poverty now removed, and at least we have remained and come back to the law and economics. So therefore, these are all become the part and parcel of our subject. So I just want to, as my chair has already made some suggestions or the comments to improve your papers, before going to the individual comments, I just want to brief some of the legislations I was looking from the scholars with the perspective of economic development and poverty. I was looking one particular legislation. The legislation name is Competition Act 2002. If no one has read, kindly read the preamble. It is clearly says for the economic development and international trade. Because we have an express provision in the MRT, the Competition Act for the economic development. Not only that, there are so many legislations which we are going to have which created economic value. Like we have recently IBC. I want to rename the name, but we are looking for the expert. IBC is not for the insolvency. It is a maximization of value of assets. So the debtor and creditors laws. So already the lawmakers are looking in such a way to create more value, and the economics has to be there, value has to be created, etc. and all. So, and also one more thing which I want to look, and Food Security Act. And we also have one thing called about the freedom of trade, as well as the another law, MSME Act. And as a teacher of, I can say as a teacher, I'm teaching the law. We want to start a company today. The government of India made under ease of business up to 15 lakh rupees of raising of a capital, you don't pay stamp duty. If I want to create a value in 15 lakhs in the market, I don't require to pay any stamp duty. It is given MSMEs and the new companies. I was also looking one of the paper, if anybody comments on the startups, entrepreneurships. Then I will go the paper-wise where that can be incorporated. In the paper number 1, it is about the poverty. To remove the poverty, a company can raise a foreign direct investment. 2 provisions are there today in our existing laws. One is the Section 8 of Companies Act, which says social welfare. There is another concept called alternative investment fund, angel funds. For the angel funds and alternative investment funds, any company can go for a private equity for removal of inequality and poverty in the society. Kindly note it down, those who have not seen. My point is that in the year 2013, we have amended our legislation. The social welfare concept is not about the state. Social welfare concept has been incorporated in the Section 8 of Companies Act. A company can raise the foreign investment, etc. That is one thing that people can add for the poverty, social inequalities, and environment. And coming to the tribal rights and the other one, empowering of the law, maybe we can see about the universities are there. And this paper I have just made one of the point about the marginalized group, and government has a lot of schemes, like for example, we have the brands, and Bhopal, we have one best place among all the places in India, a Bhopal hut, tax-free shops. It was no, you don't find any place in India. The Bhopal hut is a place where all the handicraft people can come and sell their product without paying any tax. Government pays the money to them. So Madhya Pradesh is one of the forefronter of that, and also providing the various schemes. So this is also can be done about the labor rights paper. I was looking whether anybody can use the labor code. Here I feel very bad. The government of India already made from 2020 onwards, don't use labor. Use them as an employee, call them as a ceramic. Don't call them as a karmic. Kindly look into the Ministry of Labor website or Ministry of karmic, or they don't not even karmic, ceramic. The government has given a code. There is no labor in the world. All are doing some profession or a job, that's all. So that can be reframed. It is not my one. So I was asked to teach somewhere labor law. So then I was looking the 2020 code. We have 4 codes are there. In the code, the government of India renamed. Don't call them as a labor. They are also working. We are also working. Put them as a different name, but which you can call as the equal people like that. That can be added in your paper. Then you can add into the publication as a paper on that. Then the Kolhapur is excellent, though presently I am working in Maharashtra. So the TA and Kolhapur Chappal Madam, and it requires about the international conventions. And this one thing which we talk about the sui generis law and biodiversity, international law principles. But this will be one point which I can say when a particular product comes as a commercial value and non-commercial value. Like one of the student also, participant asked, like for example, neem and haldi has become universal practice. Like for example, if I have a cough, my home they prepare a rasam, free of cost all South Indians. If I want your rasam in America, it's very costly, people says. Coffee is free. You know, South India has a rasam. There are 6 types of rasam, with pepper, with red chili, it's like that, okay? So, if any cough, immediate relief, one method. Second, milk, haldi, and turmeric, universal medicine for the throat. And in America, they is very costly. In every every part of the world, they give freely. But that has to be a very good area. It is coming up again and again because India knows for one thing, we never taken from anything from outside the world. India knows from the beginning of so many years, giving everything to the world only. That way we are very fortunate. So therefore, that is one thing we like about the traditions and knowledge. Then come with the justice with the inequitable gap. This also, as we already discussed, environment. So we have already discussed one, and the present legislation is very good. But implementation, who is going to punish the director? So that is again comes, but the CSR, now the regional director website, there are punishments are now giving. So what people are doing, I will pay 10 lakh rupees fine, I will continue it. That's happening. I accept with you, but I want to commit a wrong by paying the penalty. So that point you can add how the companies are doing, and you can also propose, let us put as a corporate crime, then put into a fraud, then present we have legislation 10 years imprisonment. That can be added on that, the strict imprisonments. Then harmonizing of IPR and the innovation paths to the tax. Here I want to have something to say about the tax is a basic revenue for a state. And therefore, the tax policy is always a question and a national debate. But the application of mathematical accuracy of game theory can be tried in India. There is nothing wrong. Because now we are using the game theory and also the theory of snake also. Recently, there is a snake theory has come. We call it the snake, no? During British period, recently they said there were so many snakes. So they called the snake catchers. They said, if anybody catches the snake and take it away and throw out of the village or home, district, we will pay money to you. So there were a lot of people came, learned the snake, catching, and they throw it out of the village. So it became snake free. And people came and asked them, please pay our money. The British people said, no snakes, no money, be happy. Then the other version of the snake theory. When the people said, if you catch a snake and give them more money, people started creation of more snakes, production of the snake, and bring 10 snakes. Paisa de do. I will give it to you. So, where the snakes are, people know, they come to there and give the money to me. Otherwise, I will throw the snakes. So, how do you use the theory? And actually, here there are two things comes. Mostly, Parliament can make a law. So, let us say tax is always the revenue. But when you talk about IPR as a property, so better they can give the incentives, and we have the transferable rights in FDI, TTs. So, therefore, that is a good article. Then you can work and go for a publication also. It's an evergreen subject actually. Because one side people say tax is a revenue, we cannot question before the court. And second say that if there is no revenue for a state, how people who are investing or incentives are not given, how it is going to work. Research and development. Then the other is about the exclusion to empowerment and legal reforms. Again, tribes. It will again link it to the presenter number 2. We have the two papers on the tribal rights. Though the government is working very, very hard to make them to come into the society, actually one of my good friend, Dr. Birpal Singh, who called me for this seminar, he is an expert of the tribal law and panchayat. He has done a field work. And particularly we have tribal university in Amarkantak in Madhya Pradesh, which started first one. Then we have here also Manas Sangralaya, where the tribal display is there. Used to tell the people of particular community, they don't want to come to our life. They said we are living very happily, we don't want to live your life. So this, in the name of the development, they are being distracted. You talk about the state of Orissa, you talk about state of Chhattisgarh, and the Ranchi coal mines, etc. So the people say we are very happy in our life, we don't want your development. There is also another side of looking about whether really we are making them to develop, or whether we are in the name of the development, we are destroying their peaceful life. We bring them to the society, taking their minerals, displacement, depriving their rights, then they are affected with the cancer, some diseases, and give the minimal compensation. The other side of the development, and therefore this also has to be made. And I like once people, everyone is writing about the living wage, Article 43. In the Article 43, there is one word, decent life. Because everyone was quoting living wage, living wage. So highlight the decent life. So India is already having the decent life for Viksit Bharat. So when you read the text of law, read very meticulously, very closely. Even one word will get your favorable judgment. Either you are a law student or a non-law student, we are all having the common sense. So if you read one particular law, I was looking why they are not talking. There one more thing has come now. Dignity rights and dignity. Article 21 is now called as the dignity rights and dignity clinics. Some national law schools already started working. Not the fundamental, not the human rights. So that is one of the development has come in the system of, these papers. All the papers are very excellent because standing and presentation, for that you prepared yourself, you came all through here and did lot of rehearsals. It is not so easy to stand and speak. We belong to the different part of the world. So I congratulate all of you to participate in the international conference and making our program as so successful, because now we are all not even a teacher, our name has been renamed as the learners. A teacher, if you say teacher, you stop learning. So teacher should not say I am a teaching, I should say that I am also learning. See, as a learner of the program, I learned a lot, and thanks to all the participants. And the last one is recent judgment of Madras High Court, where they said crypto is a property. So those who have a crypto money, be happy. So either you pay the tax, because government is asking to pay the tax, and you can purchase online and you can have it. So one side we are fighting with the property rights. Crypto is not legal tender in India, but you have to pay the tax. And Madras High Court says now, crypto can be equivalent as a property, therefore it comes under property law definitions. With these small observations, comments, I congratulate all of you, and I thank my organizers who gave me this opportunity to speak, and all the student volunteers, and my co-chair, and Dr. Padma Singh, my colleague, and the Surabhi Tiwari, and all others. And thank you once again, and thank you one and all. Thank you.
Thank you, sir, for your valuable observation on the session. With this, we end the technical session 1. We hope that deliberations today will generate insights that bridge academia, policy, and practice. Now, I would request everyone to proceed for the high tea. Thank you. Thank you.
आज का हो गया सर. मैडम वो डब्बा में क्या है मैडम?
सर वो बैम्बू का प्रोडक्ट है.
बैम्बू
प्रोडक्ट है, कॉटन है, मतलब इट इज
एनीथिंग यूजफुल?
हाँ यूजफुल.
नहीं, आई एम गोइंग टू रोहतक से फिर औरंगाबाद जा रहा है. यूजफुल है तो मैं भी कौन सी यूज करूंगा. नहीं तो मैं नहीं लेके जाएगा. वो मेमेंटो नहीं चाहिए हमको.
जी ठीक है.
नहीं सर, आई एम गोइंग टू अदर पार्ट ऑफ द वर्ल्ड.
यस सर. यस सर. वी कैन ओपन इट एंड देन यू कैन
अभी नहीं देखते वाटर बॉटल आई कैन कैरी एंड यूज इट ना मैडम. मेमेंटो मैं क्या करूँगा मैडम, बहुत है मेमेंटोस.
जी सर. ओके, तो अब सर के बाद में तो उसको अभी अनपैक कर दे सर या रूम में ले
अभी अनपैक करेंगे मैडम, क्यों इतना वेट.
अच्छा.